Item number 1 for judgment, JCR 71 of 2008.
On a close scrutiny of the evidence brought through the witnesses on their ocular version, coupled with the circumstances proved being cogent, therefore, lead only to the conclusion that the chain of circumstances brought by the prosecution is clear, cogent, and absolute, and unfailingly connects the appellant with the authorship of the murder. In the result, the JCRLA stands dismissed. The appellant, who is on bail by the order of this court, dated 2/7/2014, is directed to surrender forthwith within 15 days of this date.
I agree. May it please, Your Lordship.
So yesterday when you were placing the matter, you made a submission that you are banking upon the section 84 of the Indian Penal Code. And you said that materials are available on record.
Yes.
The court can consider the same, and since it is the requirement of law that the accused has to discharge the burden that he was having unsoundness of mind, for which he was unable to know that what he was doing was wrong or contrary to law. So now we ask you that what are those oral or documentary evidence on record to justify or to accept your submission?
Your Lordship,
Because as we have find that in 313 statement, no such plea has
No
been
such
taken,
plea.
right? Any of the prosecution witnesses has stated that the appellant at any point of time was suffering from unsoundness of mind, or at least at the time of occurrence or immediately prior to that or after that, his behavior was such that her behavior was such that from which inference can be drawn that she was having unsoundness of mind.
Your Lordship, PW 9 at page number 59.
PW9. Come to that particular line or whatever you may.
It is a fact that
Who is that?
Your Lordship, PW 9 is again one of the relatives and also a
He
witness
says
to
that the accused Gitanjali is my agnetic aunt.
aunt.
Okay, so related to the deceased, related to the appellant.
Appellant and the deceased both.
Oh, yes. And she is he has stated about also the extrajudicial confession.
Yes.
So where he has stated that about the mental
Your Lordship,
unsoundness of
Your
mind.
Lordship, cross-examination by defense,
Hmm.
para 2, 7 to 8 lines from the top.
Hmm.
It is a fact that 1 year prior to the incident, the accused was suffering from mental illness and taking medicine.
So 1 year prior to the occurrence. Now we must keep the legal position in mind that the law requires that merely at one point of time you are suffering from any mental disorder, schizophrenia, depression like that, that is irrelevant. So unless you prove, because insanity, a medical science insanity is of different kinds. To get benefit under section 84 of the Indian Penal Code, it is required that the accused has to prove legal insanity. Legal insanity which is acceptable, that he is unable to judge that what he was doing was wrong, contrary to law, all these things. So for that, his conduct prior to the occurrence, at the time of occurrence, and after the occurrence are the relevant factors. So this witness has stated that 1 year prior to the date of occurrence, the lady
was
suffering from mental ailment and taking medicine. That much he has stated.
That much is.
So from that, it cannot be inferred
Yes.
that after taking medicine, she was not cured, or that that state of mind, unsoundness of mind, was continuing till the date of occurrence.
Your Lordship, why I put forth that since he has stated that she was taking medicines and her condition was a continuance in nature, Your Lordship, is from the evidence of the defense witness.
We'll go to that defense
Yes,
witness.
yes, Your Lordship. And
You are also, apart from your defense witness, you made a submission yesterday
yes,
and today also that you are relying on the statement of PW9 only, because no other witness has
no
stated.
other suggestions have been given, but they have denied.
Okay. So this is the only line which he has stated,
Yes,
that 1 year prior to the incident, the accused was suffering from mental illness and taking medicine. That much. Okay. Now, what other evidence have
Yes.
you adduced on from your side?
Yes, Your Lordship.
Who are those witnesses?
Your Lordship, defense witness number 1 at page 69.
Yes.
He's the superintendent of jail Balasur, Your Lordship.
Please place that.
Yes, Your Lordship. I have been working as superintendent district jail Balasur since 26/8/2009. In obedience to the order of the court, I produced the medical file of the UTP. Gitanjali Pradhan, the UTP Gitanjali Pradhan was undergoing treatment by Dr. Uma Prasad Bishwal, psychiatrist of Circle Jail, Baripada.
She is DW2.
He is DW2. The said file was maintained by Dr. Umakanta Biswal and was under my custody. This is the said medical file consisting of 11 sheets, marks Exhibit A with objection.
Okay.
Again, cross-examination by prosecution. I cannot say regarding the ailment and treatment of UTP Gitanjali Pradhan. The UTP Gitanjali Pradhan is now behaving normally. At the first time of remand of UTP Gitanjali Pradhan, I was not in my present post. For every UTP, a health report is prepared at the time of his or her remand and it is maintained regularly. I cannot say if the UTP Gitanjali Pradhan was normal at the time of her first remand or not without referring to her health report. Now
So this witness was not posted as superintendent of district jail Baleswar
then at
when
the time
the appellant was taken on remand for the first time to judicial custody.
he is only
She is only banking on the state that she was under treatment at by one doctor who has been examined by DW2 and of course prove that file.
Yes,
Exhibit A.
Exhibit A.
We'll go to that Exhibit A. So please come to that evidence of DW2.
DW2, page 71. I have been working as psychiatrist at Circle Jail Baripada since 17/4/1998 till date. I have been entrusted to treat the psychiatric patient prisoners of all the jails coming under Keonjhar, Mayurbhanj and undivided Balasore district. My headquarters is fixed at Circle Jail Baripada. I have to visit other jails to treat the psychiatric prisoners. While treating a psychiatric prisoner, I have to open a file for each individual patient. This is the file of the prisoner Gitanjali Pradhan of Balasore jail regarding her psychiatric treatment, already marked as Exhibit A. As per the said file, on 13/4/2007, the jail medical officer Balasore had contacted me over phone about the abnormal behavior of prisoner Gitanjali Pradhan, Your Lordship. I have been arrested on 5/4/2007, Your Lordship. And this occurrence is of on 13/4/2007, date of first remand, Your Lordship. Abnormal behavior of prisoner Gitanjali Pradhan, and I advised him to treat her by giving antipsychotic medicine till my visit in 25/6/2007. I visited Balasore jail and examined the patient prisoner Gitanjali Pradhan and diagnosed as a case of schizodepression. Accordingly, I started her treatment. After getting treatment, she gradually improved. During her treatment on 27/8/2007, she had expressed her desire to commit suicide. But after giving treatment, she again improved satisfactorily. On my examination on 10/11/2008, I found her to be completely free from psychiatric symptoms. This is almost 1 year after your
Hmm.
Her treatment is still continued for maintenance purpose. This is my endorsement with signature regarding my treatment on 25/6/2007 in the file marked as A/1. This is my endorsement and signature regarding the condition of the patient dated 10/11/2008 in the file marked as A/2. The symptoms I found on the patient on 25/6/2000 were likely to be present earlier to my examination. But I cannot say about the duration of it. The duration varies from 1 week to 1 month to 1 year. In case of patients suffering from schizodepression, features of both schizophrenia and depression are found. On the date of my examination, she was under hallucination and paranoid delusions. As per the above symptom, she was uh, not partially but grossly impaired in respect of judgment and perception. I had treated her for the last time on 16/4/2010. If the treatment is discontinued, there is chance of recurring her earlier symptoms. On the date of my first physical examination of the patient on 25/6/2007, she was crying, she was sleepless, and she was refusing to take food and was insisting to go home. It is a fact that some of the symptoms, but not all the symptoms, may develop if a person is kept under detention away from his or her home, Your Lordship.
So
Your Lordship,
from this evidence,
yes, Your Lordship.
as it appears, on 13/4/2007, this lady came to jail
Yes.
on 5th or 6th.
5/4/2007, she has taken.
5/4/2007, she came to jail.
Yes.
Then it was reported to her on 13/4/2007 by the jail medical officer.
Yes.
Jail medical officer has not been examined.
No.
He contacted me over phone about the abnormal behavior, and I advised him to treat her by giving so medicine till my visit.
Yes.
So
That is for almost
he has not come. This lady, this doctor has not come to physically verify about her condition.
Then.
He was reported something by one jail medical officer on 13/4, and accordingly he said that uh, he advised him that to give some
Psychotic
anti-psychotic medicine till
medicine.
my visit. So from this evidence, as you say, that can it be said that on that particular day when because we are relevant is that particular day or prior to that, or so when 13/4 the evidence is coming that somebody intimated him that this lady was behaving like this over phone, that abnormal behavior. So abnormal behavior and unsoundness of mind is
Both.
completely two different things.
Yes, yes, Your
Okay.
Lordship.
So abnormal behavior, it cannot be equivalent to that. Once who is behaving abnormally is a mentally unsound.
Yes, Your Lordship.
That cannot
That
be.
cannot.
So if that is the even if we accept what that on let us say for the first time he came into physical contact on 25/6/2007, which was almost after
1.5
ଟୁ
months.
ଇଏ ଆସିଲା ପ୍ରଥମେ 5/4 ଆପଣ ଯଦି
Again.
କହୁଛନ୍ତି 5/6 ହେଲେ
2
2 ମାସ 2.5 ମାସ ପରେ
months.
ହେଲା। ତ 2.5 ମାସ ପରେ ସିଏ ଫିଜିକାଲି ତାକୁ ଏକ୍ସାମିନ କରିକିନି ଯାହା ସିମ୍ପଟମ ସେ ଦେଖିଛି। ତେଣୁ how can you say from this evidence, even if you accept it, that prosecution has failed to bring anything on that?
Dip.
So the relevant and if you are not bringing any document on record that you are taking medicines prior to the occurrence as stated by PW9. So
Your Lordship, I am harping on para 3, Your Lordship. Para 3 of the DW2, Your Lordship.
yes,
Your Lordship, where he says that The symptoms I found on the patient on 25/6/2007 were likely to be present earlier to my examination.
Yeah. But I cannot say the duration of it.
But
The
then
duration
again he
may
says
varies from 1 year
one
to so and so.
Your Lordship, now neither the defense nor the prosecution had brought what was the mental illness that she was suffering from, even if it is prior
No,
to 1
prosecution
year.
is not required to bring mental condition, because
Even the
prosecution
defense.
has to bring the whatever he has done, what the witnesses have stated, what you have done, they have to bring it
Yes,
on.
Your Lordship.
It is you what
Yes, Your
if
Lordship.
you say that it comes, because you are not taking that plea, you are not taking a specific plea, not putting any question to any suggestion that this has been done because you are suffering from unsoundness of mind.
Yes, Your Lordship.
Accused statement, please completely silent. You are bringing this thing for the first time during
Right.
defense plea, at the defense stage. And defense stage, you are examining two witnesses. One is totally not aware. He has just proved the file. And the second doctor who examined the patient, that was about 2.5 months after the occurrence.
Yes.
And he has stated that this was the, so how can from, and what she has seen, that when she examined on that particular day,
Your Lordship.
that on 25/6/2017, page number 71, I
Yes.
visited Baleswar jail, examined the patient prisoner Gitanjali Pradhan, and diagnosed as a case of seizure depression.
Yes, sir.
Accordingly, I started her treatment, and after getting treatment, she gradually. So there may be number of reasons for her. She is, after all, a lady. Number one, she was having two children, right? They are get She is separated from those two children, and an incident has happened. She is remaining in jail custody, separated from the family members. So these are the things which may cause depression in one's mind.
Your-
But what we are concerned with, that particular thing, that is legal insanity.
Yes, Your Lordship, in that very para 3 only,
Hmm.
has this been only a case of depression? Then I have no case before Your
Hmm.
Lordships. He says that, but I cannot say about the duration of it. First, he says, are likely to be present earlier to my examination. Then he says, the duration varies from 1 week to 1 year, 1 month to 1 year.
Hmm.
In case of patients suffering from schizodepression, features of both schizophrenia and depression are found, Your Lordship.
Hmm.
On the date of my this is on the date of my examination on 25/6/2007, she was under hallucination and paranoid delusions.
Hmm.
And as per the above symptom, she was not she was partially but grossly impaired in respect of judgment and perception, Your Lordship.
Hmm.
Lordship, why I deserve to be given the benefit of this paragraph is, Your Lordship, a prosecution witness has stated that I was undergoing treatment for from mental illness, Your Lordship.
Hmm.
Now, this present appellant belongs to a very poor section of society. She has also sought recourse to a state defense counsel for arguing her case, Your Lordship.
Hmm.
Her family members have not been able to provide her medical documents, Your Lordship. Now, once a witness who belongs to the state authorities has stated that the duration varies from 1 week to 1 month to 1 year, Your Lordship.
Hmm.
I am entitled to get the benefit of this, Your Lordship. Also, Your Lordship, this is not a case where the patient is only suffering from depression. He's also suffering from schizophrenia, Your Lordship. And he stated that in cases of schizophrenia,
Prosecution case of prosecution. Prosecution of case. There was no scope for the prosecution case. First time
Lordship,
If we analyze what about your conduct at the time of occurrence, then your your attempt to select a time to commit the crime when nobody was there, that means you are maintaining secrecy. These are very relevant. Keep in mind, a madman, an unsoundness of mind, he will just who are present, who are not present, it is immaterial for him. He will behave in that way. But when the child was sleeping in that cradle, the mother was not there, no other family members were there, you are committing the crime, taking that baby from that cradle, because you are not committing the crime on that cradle. ক্র্যাডল উপর অফেন্স ହେଇନି কারণ ক্র্যাডল উপর অফেন্স ହେଇଥିଲେ রক্ত ক্র্যাডলରେ ବି ଲାଗିଥାନ୍ତା. Taking the child to the
my place.
bedroom, your bedroom, and there something has happened. Her neck has been, throat has been cut almost, and she was kept inside a mouse hole, right? The weapon of offense was there, bloodstains were there in bedroom, your sari was bloodstained, all these things are there. So one thing that you are keeping secrecy. Number two, after committing the crime, they are also, you are behaving like a normal person. You are not behaving any kind of with abnormality. So why it is said that prior to the occurrence and at the time of occurrence and after the occurrence, these are to be seen. So then this is one part. The other part is the one witness has stated that when it was confronted to us and you made the extrajudicial confession, then you are trying to run away from this
Your
spot.
Lordship, that has been negated by the IO. That is first time before court.
Uh-huh.
That has been negated by the investigating officer.
No, somebody has stated that
Yes,
you are trying to
that
run
is
away
first
and
time
the
before.
people caught hold of you.
That is first time before court, Your
I do
Lordship.
not know.
Your Lordship,
That is,
PW6 has
yesterday
stated
you
that.
placed
Yes,
that. Who is
yes.
that witness?
PW6, Your Lordship.
Okay.
PW6 at page 52, last paragraph, Your Lordship.
52, last sentence.
Yes,
No,
Your Lordship.
Acha.
Yes, Your Lordship.
No, last but two, okay, one sentence. That is, she was about, yes, she was about to go away from the room, but the person assembled outside detained her.
Uh, showed me Corey and she removed the loose earth and brought out from inside and she was about to go away. That is in page 53, Your Lordship. Then the investigating officer has stated in page number 66, Your Lordship. Para 14.
So first shows the confrontation part. Section 145 says
Yes.
that in order to prove the contradictions, you must bring that statement, first confront the statement to that relevant witness so that it will be recorded in this manner. It's not a fact that I have not stated before the police that she was about to go away from the room, but the persons assembled outside detained her.
Yes, Your Lordship.
And when the IO would be examined, he has to see and prove that. So where is that confrontation?
Your Lordship, in the cross examination, she has been confronted.
Where is that?
That is page 52 only. Page 52, paragraph 4, Your Lordship, of the cross examination.
Yes.
It is not a fact that I did not state to police that accused Gitanjali showed me the corday meant for storing paddy and she removed the loose earth and she brought out the dead body from inside the loose earth and she was about to go away.
Hmm.
It has been confronted to her.
Confrontation, this go away is there, but the person assembled detained her, that is, there is no such confrontation to that effect.
No,
Now, this part, you last she was about to go away. This has been proved through the IO.
IO.
That is PW.
PW 10, sorry, 11 year. 11 at page 66.
60.
66.
Hmm.
Para 14 year.
Hmm.
Arati Pradhan, PW 6, has not stated to me
Hmm.
that she brought out the dead body from inside the loose earth and she was about to go away.
Hmm. And that very witness, paragraph 5, last line, last sentence. Gitanjali was not suffering from any disease, either physically or mentally.
Yes, sir.
This PW6 is related to you.
PW6 is related to, yes, sir.
No, to the appellant also she was related. But, and she has stated that no. So, if we say that at the time of occurrence or immediately after the occurrence about your conduct, which is also a relevant factor to adjudicate legal insanity aspect. One is that you are committing the crime in secrecy, and number two, you are keeping the body hidden in the mouse hole. Number three, thereafter you are behaving normally as if nothing has happened. I think you are asking for coin or something like
No,
that.
that was before your lordship.
Before all.
Before your lordship.
So then that is another feature, that behaving normally before even there are coin. And then, of course, this part is not there, but so these are the things which are to be taken into account, coupled with the statement of PW6.
Yes, sir.
PW6 has stated that he was not suffering from, and no plea has been taken, and the doctor who has mainly on which statement you are relying on is DW2, and that doctor examined you for the first time on 25/6, 2.5 months.
Your lordship, but my case is that that doctor had already been notified beforehand, like on my first remand only. What?
No, you see, somebody who was competent and who informed the doctor is the jail medical officer. So jail medical officer symptoms ଦେଖିକିନି ତାଙ୍କୁ ଜଣେଇଲେ,
ଆଜ୍ଞା
ସେ କହିଲେ ତାକୁ ମେଡିସିନ ଦେଇଦିଅ, ଏଇଆ
ଆଜ୍ଞା
ହଉଛି ତାଙ୍କର ଏଭିଡେନ୍ସ।
ଆଜ୍ଞା
So jail medical officer କଣ ଦେଖିକିନି ଜଣେଇଲେ, ସେ jail medical officer କିଏ, he has not been examined.
No.
So ଯୋଉ ମେଡିସିନ ତାକୁ ପ୍ରେସକ୍ରାଇବ କରାଗଲା ଏଇ ଇଏରେ, so obviously ଇଏ ଯାହା କହିଛି ଫୋନରେ କହିଥିବ, ହେଲା।
ଆଜ୍ଞା
ମେଡିସିନ ଲେଖିଲା ବାଲା ହଉଛି କିଏ ନା ଜେଲ ମେଡିକାଲ ଅଫିସର ଲେଖିଥିବେ, ଏବଂ ଆକର୍ଡିଂଲି ଯଦି ଖାଉଥିବ ସିଏ ସେଇ ପ୍ରେସକ୍ରିପସନ ଅନୁଯାୟୀ ଖାଉଥିବ,
yes, sir.
ଯୋଉଟା ଜେଲ ମେଡିକାଲ ଅଫିସର ଲେଖିଲେ। ତେଣୁ
Your lordship, another
if you verify that exhibit A, in exhibit A also that fact is mentioned, ଯେ ଫୋନରେ ଯୋଗାଯୋଗ ହେଲା, what is the behavior the jail medical officer has mentioned. Of course, that officer has not been examined. He said that patient is not taking meal. Number one, patient is behaving abnormally, not keeping his clothes. Hala? The psychiatrist of Special Circle Jail Baripada is consulted by me over telephone, and as per telephonic advice, the following medicine is given. She is to be put before psychiatrist on his visit. That was the noting of the jail medical officer who has not been examined. So this medicine seems to have been prescribed on 13/4/2007, and ଆପଣଙ୍କର ଯୋଉ appellant ଏ ପ୍ଲି କିଛି ନେଇନି ଯେ ମତେ ଆଗରୁ ମୋର ମୁଣ୍ଡ ଖରାପ ଥିଲା, ମୁଣ୍ଡର ପ୍ରୋବ୍ଲେମ ଥିଲା, ବା ମୁଁ ଜେଲରେ ମତେ ଏମିତି ମେଡିସିନ ପ୍ରେସକ୍ରାଇବ ହେଇଥିଲା, ମୁଁ ମେଡିସିନ ଖାଉଥିଲି, ତ ଏଇଭଳିଆ ପ୍ଲି ନେଇନାହିଁ। ତେଣୁ ଫାର୍ଷ୍ଟ ଟାଇମ ଯୋଉ ଡକ୍ଟର ଦେଖିଲା ଆପଣଙ୍କୁ ଫିଜିକାଲି ଅବଜର୍ଭ କଲା, ଦ୍ୟାଟ ୱାଜ 2.5 months। ତେଣୁ ଏଥିରୁ ଆପଣ କେମିତି ଆରାଇଭ କରିବେ ଆଟ୍ ଦି କନକ୍ଲୁଜନ ଦ୍ୟାଟ
Your Lordship, PW9 has stated that prior to 1 year, an incident had occurred and I was taking medicines, Your Lordship. DW2 in para 4 has stated, even if accepting that she was taking medicine, she had improved and her case of insanity is not that of a legal insanity. DW2 in para 4 had stated, if the treatment is discontinued, there is a chance of recurring her earlier symptoms. So, Your Lordship, now the defense is definitely not brought out in a detailed manner as it should have been. But I am
Yes.
to.
Yes, so okay, that is all your submission.
Yes, Your Lordship. And
Okay.
also regarding the conduct of the appellant, Your Lordship, had I had full judgment about what I have done, or I had any intention to do away with such, I would not have been the person who would have showed the body that I've hidden it over here, and I would not have disclosed that fact. 25 days kid, Your Lordship, I would have done away with the body, since I have done it without, in the absence of any other family member, Your Lordship. And that, as the prosecution witnesses have also stated, that we are a joint family who is living in a pretty, my house is pretty secluded from their house, Your Lordship. So I would have taken recourse to methods to do away with the body of a 25 days old kid, Your
But
Lordship.
there was no scope on your part to take the body somewhere else. Because the houses of other persons,
Yes,
the
yes,
other family members are there. How can you take the body in such a position? Blood must be there.
Your Lordship.
So, if you would have committed the crime in that cradle itself, it would have been detected, because the moment you do the crime and take the body to your bedroom, there will be trailing of blood from the cradle to the home. So you very cunningly took it to the house, and there might have just pressed the mouth of that so that the cry would not be heard, and caught the neck and kept it inside the. So
Your Lordship, that is where is the difficulties. Even if I have 3 kids of my own, Your Lordship, even if I have taken the baby for any purpose that relatives generally take hold of infants, at what point of time does it enter my mind and my personality changes and I've got a schizophrenic attack, Your Lordship? That is to be seen, Your Lordship. Because even if saying that the prosecution has brought out from my mouth that I was having a motive of killing the child because I was having a quarrel with his mother, Your Lordship, but at the just before the incident I have asked for tobacco, Your Lordship,
mhm.
and just before the incident I have had good terms with the mother of the child,
No,
Your Lordship.
that is not good term. That does not indicate that you are suffering from any kind of mental unsoundness mind. You are behaving like a normal person, asking for tobacco.
Your Lordship,
So
that is what is my whole situation, Your Lordship. This whole disease is about a person behaves normally, but there are moments when he loses his own perception, Your
so how
Lordship.
can it be? No,
This cannot.
if you would have committed the crime in the cradle itself, Hala, called others, matter is something different. But you are taking the baby from that cradle, and the other family members were very close by. Nobody is hearing the cry of that child, because the every possibility is that you are keeping the mouth shut and cutting the throat. That is why, otherwise, the mother was very close to that.
Yes, yes, Your
She
Lordship.
could have heard this cry of the child.
Your Lordship, what I would say is ki taking away that child, Your Lordship, does not in no manner points to my intention of doing away with that child. I might have taken that child just for as
No, no, no. Hypothetical argument would not do. The child was alone in the cradle.
Your Lordship, even if
The child was found inside your bedroom, and her neck was cut,
Your
and
Lordship,
weapon was there. The entire blood stains were there. Your sari was stained with blood, and offense was not committed definitely on the cradle. It was committed inside
yes,
that
Your
room,
Lordship, yes, Your
right?
Lordship.
From the situation, you cannot say that it was done in that cradle and then the child was taken. That was done in that room, and the very fact that nobody is hearing the cry, that means every step has been taken to maintain all kind of secrecy, to see that nobody hears the cry. And then, after the commission of the crime, again you are not disclosing anybody, keeping secret. So these are the factors which go against unsoundness of mind. Then when you confronted, of course you have shown that. So, but uh, the sometimes the suppose an accused is arrested and shows the dead body, shows the weapon of offense, can it be said that
No, Your Lordship, that
he
cannot.
is suffering from unsoundness of
No,
mind?
no, that cannot be said, Your Lordship.
So
Your Lordship, but what I intend to say is ki because we do not know what was we do not know also what is her medical history and how does this schizophrenic
you are
depression
not
gets
doing
attacked.
anything. Two of the witnesses, prosecution witness, one is stated that 1 year prior to the occurrence, there was some kind of, or he was taking medicine. But the relevant factor is the what happened at the time of occurrence.
Yes, Your Lordship.
And the other witness, PW6, you have brought out in the cross examination that he was not suffering. It is not in the chief,
Your Lordship.
it's in the cross examination. And moreover, you are not taking any plea. So if you are not taking any plea, it's not a case of that other things which you are, uh, uh, even if you are not taking the plea, if the materials available on record, the court can certainly take into account. But ultimately, it is by
Conduct.
your burden lies on you. So if you are not taking the plea in the uh, 313 statement, and the not proving any medical documents, and two of the witnesses examine on your behalf, that is DW1 and DW2. One's evidence is totally irrelevant because he has proved that
The
file
medical file.
itself. Okay. The other says what happened immediately after the occurrence, his evidence is silent. But he stated that after few days, I got the telephone call from the jail medical officer who has not been examined. He said me like this, ଖାଇବା ଛାଡି ଦେଇଛି, ତା ପୋଷାକ ପତ୍ର ଠିକ ସେ ରଖୁନି ହେଲା, ତେଣୁ ବ୍ୟବହାର abnormally କରୁଛି, ତେଣୁ ଇଏ ତାକୁ କହିଲା ଯେ ତାର ଏ ମେଡିସିନ ଦେଇଦିଅ. So some medicine has been prescribed. So again, the that doctors, even if we accept that that doctor has stated he has not been examined, so from that medicines or that behavior which he saw, can it be come to again the relevant date or the time is that is the consistent settled position of law, that what is how you are behaving 1 year back, 1 month back, or after 1 month after the occurrence, those are not the relevant factors. The relevant, the crucial part is that how you are behaving or at the relevant point of time. So even if you are if that point of time you succeed, even if your behavior was normal, you can get the benefit. But crucial point of time is that, so many things goes against you, except that she pointed out that dead body took that taking in the, so otherwise, and asking for coiny prior to the so and so, maintaining secrecy, taking the child, committing the crime so that nobody could be aware of it, then maintaining ପାଗଳା ପାଗଳା ହେଇଥିଲେ ଅଲଗା ଟାଇପ ର ବିହେଭିୟର ହବ.
Your Lordship, that is what is my point, Your Lordship. That of course we failed in bringing out that how has been her
ଏ
behavior.
ଟାଇପ ର ଜଣେ ଗୋଟେ ଛୁଆଟାକୁ, ସେ ନିଜେ ଗୋଟେ ଛୁଆର ମା, ଦିଟା
ତିନିଟା
ଛୁଆର ମା ହେଲା,
ତିନିଟା
ହଁ ଦିଟା ଛୁଆର ମା ଗୋଟେ ଛୁଆଟାକୁ ତଣ୍ଟି କାଟିକିନି ମାରିଲା ପରେ ତାର ଷ୍ଟେଟ୍ ଅଫ ମାଇଣ୍ଡ ଯୋଉ ଟାଇପ ର ହବ, have you find any evidence to that effect, so that he is maintaining very calmly, ଅନ୍ୟମାନଙ୍କ ସାଙ୍ଗରେ କିଛି କେହି ଜାଣିପାରୁନାହାନ୍ତି, ଖୋଜା ଖୋଜି ଚାଲିଛି, ଆରେ ଛୁଆ କୁଆଡେ ଗଲା, ଛୁଆ କୁଆଡେ, କାହାକୁ କହୁନି, ଚୁପଚାପ ରହିଛି.
Yes, Your Lordship. Your Lordship, though the doctor says that in her case the features of both schizophrenia and depression are present, Your Lordship.
All right. Yes, Mr. Mishra.
Lordship. Lordship has already seen the evidence of PW 5, 6, and 9, who are the witnesses to the extrajudicial confession, which is out of free will and truthful and reliable, my lords. Lords, just to
some evidence he has pointed out,
Lordship,
that some persons assembled there
Lordship,
after the occurrence, and not only that, she was also tied.
Tied up, my lords.
So, what is your submission on that?
Lordship, to remove all cast of doubt, your lordship may take PW 3. He is also a witness to the extrajudicial confession, my lords, and he has clarified that
because
aspect.
Law requires that it should be voluntary one.
Lordship,
right?
it will be voluntary.
And if the court finds that it is there is any kind of inducement, there is any kind of threat, any kind of promise, as enumerated under Section 24 of the Evidence Act, then extrajudicial confession goes.
Lordship.
So you have to keep in mind and say that that was a voluntary one.
Lordship.
Yes.
Here the case is that the accused, she was tied after she had made the confession, your lordship. Lordship may take page 44.
Page 44. Whose evidence you are paying?
That is the cross-examination of witness number 3, your lordship.
PW3.
My lord.
Yesterday she submitted that there are 3 witnesses to the extrajudicial, 5, 6, and 9.
My lord.
PW3 is not a witness to the extrajudicial confession.
No, he has also stated, your lordship.
But she stated that only 3 witnesses stated.
Your Lordship,
PW3 also stated.
PW3 afterwards.
No. Please let us see that So PW5, mother of the deceased. In her examination, she stated that we entered into the house where it was kept. We saw the child with some cancer, but in the processing.
In the cross, my lord. Yes.
I had not.
That had been tested.
I was going, I cannot. I cannot. I did not accompany. No, that is also statement by PW6 also, that she did not accompany. Yes. I alone went, somebody has stated for us that I alone entered into the situation. I accompanied Gitanjali alone. So she went alone. If she is the only they say that let us say PW5 सामनारे what about PW6 जे कि एकुटिया जाइतला से घर भितर एवं एकुटिया डिस्कवर कला ताकि जे देखिला एवं तारी पाखरे पहिला एक्स्ट्रा जुडिशियल कन्फिशन तापरे जोटा ये कहउछन हाँ सेटा होची तापरे देन माने सेटा लोक माने आसिले ताकू बांधी पकेले ये एगुडा कहउची एक्स्ट्रा जुडिशियल कन्फिशन परे we have to see that whether at the time of making that extrajudicial confession there was any kind of obviously once it is disclosed the people coming to know about it they will be certainly got angry and they it is very natural for them to tie that lady. So that's a different matter but যদি हाँ evidence আসता ताकि जमा total मानी अभी बढ़िया मेरे चल रहे कि बांधी देला और माने हाँ ସେଇଟା କୁ ସେ ଘର ଭିତରକୁ 6 ନମ୍ବର ସାକ୍ଷୀକୁ ନେଇକି show moto କରେ. So he is pointing out I saw event. Strong in her lap. That's what we could show a lot of the Geo with the because you can have 2 daughters and 1 son. I cannot say what was the age of her son. When I heard about the missing my daughter from Dolly, she was having her son in her lap. So, the beat time, that's what. So this is a clinching circumstance. Actual on a circumstance. But you are concerned from the next yes. The day when she committed the crime, should have been proved that she was having that mental disease. With somewhere conduct out the he think of the negative judge for you. So the professor Marcel was proceeding 1 week maybe she did the conference comes to no, preceding 1 bad incident PW12%. Varies from 1 week to 1 week. So, telephone was consulted by the jail medical officer. And he was forwarded to jail incident that incident of in April month. They are just saying What is the date of occurrence?
5/4/2007, Your Lordship.
2007. 34. ये record at ये देखो. Eight on it, right? Trial court report. Right. And apprentice has some should depend, but her mental sport has its ones. She has some attractive PW2. She 5 times the data data. Don't she exhibit refusing, insisting to vote, and she was well talking. Scenario, and I will lead for the this comprehensive housing. Family facing conversation with his one. So symptoms that by this one. So he depression in the other lab is not having prevent this they thought me. He may be put a research medical officer for check-up and real observation. जोटा ही ये physically जो jail medical officer think that patient is not taking it. They are not keeping his clothes. The psychiatric Swanso inside the jail Swanso is consulted by me and as for the telephone Swanso, the following medicine given for this treatment, so use the life intervention. Keep not taking it for all his cloth. Giving them. telephone call advise them. uh, she's not making any submission that if 84 is excluded, then she has no case.
Lordship.
Because ଯାହା ବି ଘଟଣା ହେଇଛି ଯୋଉ ଟାଇପ ର ହେଇଛି circumstantial evidence ରେ ଯୋଉଠି recovery ହେଇଛି ଏଗୁଡାକ extra judicial confession ଏଗୁଡାକ ସବୁ ପ୍ରମାଣ ରହୁଛି. But what you have got to say 84, she has stated that my entire case rests upon 84 of the Indian penal. How do you meet it? Because the one of your witness at least says that he was not I think PW9 actually,
9, yes.
prior to 1 year and taking medicine. Not that she has stopped medicine, but taking medicine. Of course, that medical documents have not been proved, and that person is also related to both. That means to the appellant and also to the informant. That she is suffering from mental illness and taking medicine. Then coming to the next witness, if we find that DW2, even if we say that DW1's evidence is not that relevant because he has just proved the file, which has also been proved by the doctor, DW2. Doctor's evidence is that 7-8 days, I think, or 8 दिन खंडे हबो कारण 5 रे हेले 8 दिन पर 9 दिन हुआ से फोन कॉल पाइले जेल मेडिकल ऑफिसर तांको एई टाइप रो कहले तणो से जो कहले दैट इज रिलेवेंट जे ये खाइबा खाया पिया पी छाड़ देछि abnormally behave କରୁଛି and not keeping his clothes her clothes his cloth ଲେଖାଇ her clothes ହବ ତାମାନେ ସେ ଲୁଗାପଟା ବି କିଛି ରଖୁନି ଫୋପାଡ଼ି ପୋଡ଼ି ଦଉଛି ତ ଏଥିପାଇଁ ଯେତେବେଳେ କହିଲେ ସେ ତାକୁ ମେଡିସିନ ପ୍ରେସ୍କ୍ରାଇବ କରିଛନ୍ତି ଏବଂ ଯୋଉଟା କି DW2 ମଧ୍ୟ ଆସିକିନି ପ୍ରମାଣ କରିଛନ୍ତି. So of course jail medical officer has not been examined, but the document has been proved. Exhibit A is that entire file that has been proved, and it is stated by also that so entry are there, evidence of another doctor is there, and the document has been proved. तो এই circumstance रे যদিও সে প্লি নেইনি specific plea তাহলে it cannot be said that there was totally no material on record that she was having some kind of mental problem with her and for which she was taking medicine. Then question again comes back that yes, mental ailment if it is there, then again that is to be legal insanity.
Lordship.
So legal insanity, if that is to be proved by this taking into account about your behavior at the time, so on, so on. So what has been pointed out by her, ଯେ ତାକୁ ନେଇକିନି ସେ ଯଦିଓ କାମଟା କରିଦେଲା କେହି ଜାଣିନଥିଲେ ଦେନ୍ ଯେତେବେଳେ ଇଏ ପଚାରିଲା ତାଙ୍କୁ ନେଇକିନି ନିଜ ଘରକୁ ନେଲା ସେ ଜାଗା ଦେଖେଇଲା without any coercion and pressure କିଛି ଦେଖେଇନି ସେଟା that something counts that or state of mind ତାହେଲେ ସେ ହୁଏତ ଚୁପଚାପ ରହିଯାଇଥାନ୍ତା ମାନେ କୁଆଡେ ଗଲା ତାପରେ ପରେ ଖୋଜାଖୋଜି ହେଇଥାନ୍ତା କାରଣ ବାହାରେ ତ କିଛି ରକ୍ତ ପଡୁନଥିଲା ଯଦି ଚୁପଚାପ ରହିଯାଇଥାନ୍ତା କୌଣସି ତାକୁ ନେଇକିନି ଦେଖଉଛି ଯେ ଇଏରେ so maybe that may be one of the reason that perhaps her mental condition was not sound at that point of time. तो ଏଇ ଯୋଉ କେତେ ଗୁଡାକ material ଯାହା ବି ସେମାନେ ପ୍ରମାଣ କରେଇଛନ୍ତି, so whether he is able to make out a case to get the benefit under section 84 IPC or not, that is to be seen.
Lordship. Lords, I would like to submit it through a judgment, Your Lordship, covering the facts of this case. Dear my lords, the Supreme Court have clearly stated how it is to be tested. Once we presume that there is medical insanity, what are the tests to be done to conclusively find out that there was legal insanity as well, Your Lordship? Lordship may come to the 8th page, my lords. Lords, the middle paragraph, Your Lordship, in all cases.
Paragraph?
Paragraph 7, Your Lordship, it starts from page number 7 and continues to page number 8.
Paragraph 8 or page 8?
Page 8, Your Lordship, paragraph number 7, which is in continuance, Your Lordship.
The paragraph 7 starts with section 84 lays down.
My lords, should I place the whole paragraph?
Yes.
Section 84 lays down the legal test of responsibility in cases of alleged unsoundness of mind. There is no definition of unsoundness of mind in the IPC. The courts have, however, mainly treated this expression as equivalent to insanity. But the term insanity itself has no precise definition. It is a term used to describe varying degrees of mental disorder. So, every person who is mentally diseased is not ipso facto exempted from criminal responsibility. A distinction is to be made between legal insanity and medical insanity. A court is concerned with legal insanity and not with medical insanity. The burden of proof rests on the accused to prove his insanity, which arises by virtue of Section 105 of the Evidence Act 1872 and is not so onerous as that upon the prosecution to prove that the accused committed the act with which he is charged. The burden on the accused is no higher than that resting upon a plaintiff or a defendant in a civil proceeding. In dealing with cases involving a defense of insanity, distinction must be made between cases in which insanity is more or less proved, and the question is only as to the degree of irresponsibility, and cases in which insanity is sought to be proved in respect of a person who, for all intents and purposes, appears sane. In all cases where previous insanity is proved or admitted, certain considerations have to be borne in mind. Main summarizes them as follows. This is the most relevant part, Your Lordship. Whether there was deliberation and preparation for the act, whether it was done in a manner which showed a desire to concealment, whether after the crime the offender showed consciousness of guilt and made efforts to avoid detection, whether after his arrest he offered false excuses and made false statements. All facts of this sort are material as bearing on the test which Bramwell submitted to a jury in such a case. Would the prisoner have committed the act if there had been a policeman at his elbow? It is to be remembered that these tests are good for cases in which previous insanity is more or less established. These tests are not always reliable where there is what Maine calls inferential insanity. Under Section 84, a person is exonerated from liability for doing an act on the ground of unsoundness of mind if he, at the time of doing the act, is either incapable of knowing A, the nature of the act, or B, that he is doing what is either wrong or contrary to law. The accused is protected not only when on account of insanity he was incapable of knowing the nature of the act, but also when he did not know either that the act was wrong or that it was contrary to the law, although he might know the nature of the act itself. He is, however, not protected if he knew that what he was doing was wrong, even if he did not know that it was contrary to the law. And also if he knew that what he was doing was contrary to the law, even though he did not know that it was wrong. The onus of proving unsoundness of mind is on the accused. But where during the investigation, previous history of insanity is revealed, it is the duty of an honest investigator to subject the accused to a medical examination and place that evidence before the court. And if this is not done, it creates a serious infirmity in the prosecution case, and the benefit of the doubt has to be given to the accused. The onus, however, has to be discharged by producing evidence as to the conduct of the accused shortly prior to the offense and his conduct at the time or immediately afterwards. Also by evidence of his mental condition and other relevant factors. Every person is presumed to know the natural consequences of his act. Similarly, every person is also presumed to know the law. The prosecution has not to establish
Has
these
to
facts.
establish these facts.
My
Has
lords.
not to establish facts.
My lords.
Ah.
There are 4 kinds of persons who may be said to be non-compos mentis, not of sound mind. That is, an idiot, one made non-compos by illness, a lunatic or a madman, one who is a drunk. An idiot is one who is of non-sane memory from his birth, by perpetual infirmity without lucid intervals. And those are said to be idiots who cannot count 20 or tell the days of the week, or who not know their fathers or mothers or like. A person made non-compos mentis by illness is excused in criminal cases from such acts as are committed while under the influence of this disorder. A lunatic is one who is afflicted by mental disorder only at certain periods and vicissitudes, having intervals of reason. Madness is permanent. Lunacy and madness are spoken of as acquired insanity, and idiocy as natural insanity. Section 84 embodies the fundamental maxim of criminal law, that is, actus non reum facit nisi mens sit rea. An act does not constitute guilt unless done with a guilty intention. In order to constitute an offense, the intent and act must concur. But in the case of insane persons, no culpability is fastened on them as they have no free will. The section itself provides that the benefit is available only after it is proved that at the time of committing the act, the accused was laboring under such a defect of reason from disease of mind as not to know the nature and the quality of the act he was doing, or that even if he did not know it, it was either wrong or contrary to the law, then this section must be applied. The crucial point of time for deciding whether the benefit of this section should be given or not is the material time when the offense takes place. In coming to that conclusion, the relevant circumstances are to be taken into consideration. It would be dangerous to admit the defense of insanity upon arguments derived merely from the character of the crime. It is only unsoundness of mind which naturally impairs the cognitive faculties of the mind that can form a ground of exemption from criminal responsibility. Stephen, in History of the Criminal Law of England, volume so and so, has observed that if a person cuts off the head of a sleeping man because it would be great fun to see him looking for it when he woke up, would obviously be a case where the perpetrator of the act would be incapable of knowing the physical effects of his act. The law would the law recognizes nothing but incapacity to realize the nature of the act and presumes that where a man's mind or his faculties of rationification are sufficiently dim to apprehend what he is doing, he must always be presumed to intend the consequence of the action he takes. Mere absence of motive for a crime, howsoever atrocious it may be, cannot, in the absence of plea and proof of legal insanity, bring the case within this section. This court in Sherali Wali Muhammad versus State of Maharashtra held that the mere fact that no motive has been proved by why the accused murdered his wife and children, or the fact that he made no attempt to run away when the door was broken open, would not indicate that he was insane or that he did not have the necessary mens rea for commission of the offense. Now, next paragraph is also very important, Lordship. Mere abnormality of mind or partial delusion, irresistible impulse or compulsive behavior of a psychopath affords no protection under Section 84, as the law contained in that section is still squarely based on the outdated MacNaughton rules of 19th century England. The provisions of Section 84 are in substance the same as those laid down in the answers of the judges to the questions put to them by the House of Lords in McNaughton's case. Behavior, antecedent, attendant, and subsequent to the event may be relevant in finding the mental condition of the accused at the time of the event, but not that remote in time. It is difficult to prove the precise state of offender's mind at the time of the commission of the offense, but some indication thereof is often furnished by the conduct of the offender while committing it or immediately after the commission of the offense. A lucid interval of an insane person is not merely a cessation of the violent symptoms of the disorder, but a restoration of the faculties of the mind sufficiently to enable the person soundly to judge the act. But the expression does not necessarily mean complete or perfect restoration of the mental faculties of the original condition. So, if there is such a restoration, the person concerned can do the act with such reason, memory, and judgment as to make it a legal act. But merely a cessation of violent symptoms of the disorder is not sufficient. The standard to be applied is whether, according to the original standard adopted by reasonable men, the act was right or wrong. The mere fact that the accused is conceited or irascible and his brain is not quite all right, or that the physical and mental ailments from which he had suffered rendered his intellect weak and had affected his emotions and will, or that he had committed certain unusual acts in the past, or he was liable to recurring fits of insanity at short intervals, or that he was subject to getting epileptic fits, but there was nothing abnormal in his behavior, or that his behavior was queer, cannot be sufficient to attract the application of this section. This is the entire. So here, Lordship, there was deliberation and preparation on part of the accused, my lords. There was clear deliberation and preparation. Why I am submitting that is because one of the circumstances that the trial court has also taken is that the accused was the last person to be seen near and around the child, your lordship. When the mother was going to get the water from the tank, the accused had come to ask for tobacco. So my humble submission is that would come under deliberation and preparation, as if she had come to scout the spot, your lordship. Now, your lordship, whether it was done in a manner which showed a desire to concealment. Lords, after the crime was committed, if she had just held the body and sat down, I would have pleaded that it was a case of legal insanity. But she consciously put the body inside the rat hole, your lordship. So there is clear desire of concealment. Then, your lordship, the offender showed consciousness of guilt and made efforts to avoid detection. She was just sitting in her room. Everybody was searching for the body. I mean, of the for the baby who was lost, as per them.
No, she. I think she came out of the room after the committing the crime.
She was sitting with her own baby on her lap. So that's what that clearly shows that she was conscious of the guilt. If she was not conscious of after hiding the body, and there is no evidence that she was also searching for them or anything like that. So therefore, on the first occasion when she was asked, after suspicion of PW6, she was questioned, your lordship, and she did not give any answer. After pestering her with questions, she finally admitted. So therefore, she has made sufficient effort, I would say, to conceal her guilt, your lordship. So this second test
evidence on record that after pressuring her only she stated so.
That is there, your lordship.
PW6. He has stated simply she asked her, then she
repeated question.
Yes.
Repeated word also is not there. She has not uttered.
No, she
told me the place of occurrence gave to so and so. Accused in her hand removed as I found the neck. I inquired about the cutting of the neck and accused. Yes. No, there is no repetition of it. So simply admitted that she put the dead body in a cloth so and so.
Yes, Lordship, PW6 has stated. In her cross-examination, page 52, paragraph 3. 4 to 5 times, I loudly asked Gitanjali about the daughter of Swarnalata. So that is what I'm referring to, your lordship. And also the evidence of my lordship. Yes, evidence of PW 9, Your Lordship. For page 58, the first paragraph itself. First, Gitanjali Pradhan was reluctant to give any reply. But when she was repeatedly asked, she confessed that she had murdered the deceased by cutting her throat. So and so.
ସେ କଣ କରିଛି ନା ଏ ଯୋଉ ମୂଷା ଗାତ ଭିତରେ ଛୁଆଟାକୁ ପୁରେଇଛି, କାଟି
Lordship.
ଦେଇକିନି ପୁରେଇଲା ପରେ ତାକୁ ମାଟିରେ କଭର କରିଦେଇକିନି ଗୋଟେ କଢେଇଟାକୁ ରଖିଛି।
My lords.
ସେଇ ଯୋଉ କଢେଇଟା କହୁଛି, କଢେଇଟାକୁ ଇଏ କଲା ପରେ ଘୋଡେଇକି ରଖିଲା ପରେ ସେ କଢେଇଟାକୁ ରିମୁଭ କରିଛି, ତାପରେ ଲୁଜ ଆର୍ଥକୁ ରିମୁଭ କଲା ପରେ ଡେଡ ବଡିଟା ମିଳିଲା। ସେଇଟା ହଉଛି କେସ୍। ମୂଷା ଗାତ ଭିତରେ ସେ ଛୁଆଟାକୁ ରଖିକିନି ଏଇ ଜିନିଷ ସେ କରିଛି।
But this paragraph is summarized, Your Lordship, that would she have committed the crime under the elbow of a police officer? This conduct clearly does not indicate that.
କଣ କି ମାନେ କେତେଟା କେସ୍ ରହିଛି, ମନେକର ସେ ଇଏ କଲା ପରେ କ୍ରାଇମ ଟା କମି ଦେଇକିନି ସେଇ ରୁମ୍ ଭିତରେ ଲୁଚିକିନି ରହିଥିବ, ଯେ ଏଗୁଡା ହଉଛି ପାଗଳାମିର ଯୋଉ ଇନସାନିଟି। ଏଠି ସେମିତି କିଛି ନାହିଁ, ମାନେ ନର୍ମାଲି ସେ ତା ଛୁଆ ଧରିକିନି ଅନ୍ୟମାନେ ଖୋଜୁଛନ୍ତି, ସେ ତାର ଚୁପଚାପ ରହିଛି, କାହାକୁ କିଛି ଡିସକ୍ଲୋଜ କରୁନି। ତାପରେ ଖୋଜିବାଟା ଆହୁରି ବଢି ଯାଇଛି, ମାନେ ପାଉନାହାନ୍ତି, ସୋ ଆଂଜାଇଟି ଲୋକ ବି ତାପରେ ସିଏ
She has confessed.
ହଁ। ଦେନ୍ ଏଇ ଯୋଉ ଏଭିଡେନ୍ସ ଆସିଛି, ସେ ତାକୁ ଘରକୁ she showed me the place in the house. The accused went inside. এটা PW6 ର evidence, ଯୋଉଟା କି very vital, ସେଟାକୁ ଯଦି ଆସିବା, I inquired Gitanjali who was in the dori of her house. Her house was close to our house. Then the Gitanjali went inside the bedroom. I followed her. She showed the place inside the house where the kodei was kept. মানে কড়াইটাও ঘোড়েইকিন রাখি সে মুসা গাতাটাও সেটা কভার করেছি। Underneath the kodei some loose earth was found. It page number 52.
She has also even not stated that I asked her about the that girl of PW5. So much. Then I inquired from Gitan who was in Dolly for house. Her house was close to our house. Then the accused went inside her bed, and I followed her. She showed me the
place inside the house where kodai meant for storing paddy was kept. Underneath the kodai some loose earth was found. Accused in her hand removed the loose earth, brought out the dead body. I found the neck was cut and inquired Swanso. He admitted that Swanso. Then she put the dead body on a cloth lying on the floor. She was about to go away from the house. Swanso. This is Kohini Chanandu. That
Also, Lordship, DW2, which my learned friend is relying on heavily, he has not, he has not specified the exact time period from which this insanity in fact started.
ଠିକ
Your Lord.
କହୁଛି ଯେ ହେଇପାରେ, ମାସେ ହେଇପାରେ, ବର୍ଷେ ବି ହେଇପାରେ, ଗୋଟେ
Lordship.
just ଏଇ type ର answer ଦେଇଛି।
And
One
he
week
has examined
to
after
1 month to 1 year.
my lords. So that has not been concrete. The onus is on the accused
Right,
to prove that. So this
Of
evidence,
course, onusটা ଏତେ stiff ନୁହେଁ,
Lordship,
but medical evidence ରୁ ଯାହା ଜଣା ପଡୁଛି ଯେ କିଛି ତାର ବିହେଭିୟର ଟା ଟିକେ abnormal ଥିଲା, କାରଣ ସେ ଯୋଉ ଲୁଗାପଟା କିଛି ପିନ୍ଧୁ ନଥିଲା,
my lords.
ଆଉ that was the ଖାଉନଥିଲା, କାନ୍ଦୁଥିଲା, ଏଇ ସବୁ ଜିନିଷ ଗୁଡାକ ରହୁଛି। ତେଣୁ
And even if in the lowest side, we accept that it is a old case of 1 week back.
Lordship.
So then also when the incident, in between incident and the accused who was remanded to jail custody was 8 days.
ହଁ 8 days, କାରଣ 13 ତାରିଖରେ ଏଇ ଜିନିଷ ସିମ୍ପଟମ୍ସ ଆସୁଛି, 13 तारिख रो फाइंडिंग होची जेल मेडिकल ऑफिसर रो जे लुगापटा किछि पिंधुनी आउ बिहेवियर abnormal बिहेवियर थिला आउ खियापिया किछि करूनी तेणु कंसल्ट करा गला परे ताकू मेडिसिन्स दिया आइछि सब
DW2 has also stated in her cross that it is a fact that some of the symptoms, but not all, will develop if a person is kept under detention away from his or her home. The last line, Your Lordship. Your Lordship, these symptoms which is
further cross-examination.
My Lordship.
No, cross-examination.
Cross, Your Lordship, page 72, the very last sentence. So these symptoms.
The symptoms माने जने खाଇବା पिवा छाड़ दो it is all right but ए जो लुगापटा खोली कि नहीं
Yes, schizophrenic symptoms.
she's a lady सेगुड़ा सेगुड़ा को गोटे टाइप रो देखौसी abnormal behavior सहित निज लुगापटा माने ये करबा सेगुड़ा होसी आउ बाकी जो अन्य खाଇବା पिवा न चलले सेटा मध्ये हेई परिबो जने नॉर्मल लोक मध्ये की सेटा हेई परिबो कि छाडी देला बेली जने खाउनी बेली से abnormal बा mental unsoundness सेटा कुहाई जाई परिबो
That's why the doctor has said it is a fact that some of the symptoms, but not all, of this may develop if a person is kept under detention away from his or her home.
कारण 25-6 से जो symptoms देखी these are very natural: crying, sleeplessness, refusing to take food, and insisting to go home. These are normal.
Because she had
already taken medication.
Children. She had 3 children and she was kept away from the children.
ये जो medicines गुड़ा को नेला धरी 2.5 मास परे से गुड़ा को सेति पई से सबसाइड कर जाईची सेतोल को आ ये जो जिंसटा नाही किछि
Your Lordship, I have one small request, Your Lordship. Your Lordship, may give me one more day. I have to supply the judgments. I just don't have the copy of the judgments. I will be permitted to place the judgments before Your Lordship.
We are giving
to section 84.
Yes, Your
we are
Lordship.
giving benefit to you. Don't worry about it. Take down CRLA number 419 of 2010. The appellant Gitanjali Pradhan faced trial in the court of ad hoc additional session judge FTC2 Balasur in sessions trial number 102/206 of 2009/2007. For offense punishable under section 302 of the Indian Penal Code on the accusation that on 5/4/2007 at about 7 a.m. at village Putina under Bhograi police station in the district of Balasore, she committed murder of one Puja Pradhan, bracketary, hereafter the deceased, who was a baby aged about 25 days, baby of 25 days. The London Trial Court, by judgment and order dated 3/7/2010, found the appellant guilty of the offense charged and sentenced her to undergo rigorous imprisonment for life and to pay fine of rupees 2,000 in default to suffer rigorous imprisonment for 6 months. The prosecution case, as per the first information report, bracket Exhibit 5, lost by Shankar Pradhan, PW3, before the officer in charge of Kamarda police station on 5/4/2007, in short, is that on that day at about 8 a.m. in the morning hours, he returned home from the field and came to know from his sister-in-law, Swarnalata Pradhan, bracket PW5, that she had gone to wash the utensils to a pond after letting the deceased to sleep in the cradle on the veranda of her house, and after returning she found that the deceased was not present in the cradle. Another sister-in-law of the informant, namely Arati Pradhan, PW6, also searched for the baby, and the dead body of the baby was found inside the room of the appellant. In a mouse hole, and it was found that her throat had been cut. Her throat had been cut. When PW6 confronted the appellant, she admitted to have cut the throat of the deceased by means of a sickle, and when she disclosed about the same, one Jyotsna Rani Giri and Kabita Pradhan heard about it. On the basis of such report, the officer in charge of Kamarda police station registered Kamarda PS case number 30 dated 5/4/2007 under section 302 of the Indian Penal Code against the appellant. PW 11 himself took off investigation of the case. During course of his investigation, he examined the informant and sent message to SP Balaswar for deputation of scientific officer to visit the spot. PW 11 reached at the spot, and during his spot visit, he found the dead body of the deceased lying on the veranda of the house of the appellant with cut injury on the neck. He held inquest over the dead body in presence of the witnesses and prepared the inquest report, Exhibit 1. He sent the dead body for post-mortem examination. During his spot visit, he found bloodstain marks on the floor of the house of the appellant. So also on the mouse hole, and further found a sickle stained with blood lying on the floor of the house of the appellant. Bloodstain clothes were found lying on the floor of the house of the appellant. He prepared the spot visit report by Exhibit 10, so also the spot map by Exhibit 11. The scientific team arrived at the spot on the same day and collected the incriminating materials, prepared a report. The photographs of the scene of crime was taken, and the bloodstain sample were collected from the floor of the house. So also from the mouse hole, the sickle stained with blood, blood-stained clothes, blood-stained saris of the appellant were also seized after it was produced by the scientific officer under seizure list exhibit 2. The appellant was arrested on the same day and forwarded to court. The cradle was seized as per seizure list exhibit 4, and it was given in the jima of the father of the deceased. The nail clippings and blood sample of the appellant was collected by Medical Officer District Jail Balasore, which were seized as per seizure list exhibit 13 by the IO. He received the postmortem report, sent the weapon of offense, that is sickle, to the medical officer for his opinion, and made a query about the possibility of the injury sustained by the deceased through such sickle, and received the query report. Stop. He sent the seized exhibits to RFSL Baleswar through GMFC Jaleswar, and the C report by exhibit 15 was also received on 22/7/2007, he handed over the charge of investigation to SI of police Trilochan Sethi. Who, on completion of investigation, submitted charge sheet against the appellant under section 302(201) of the Indian Penal Code. After submission of the charge sheet, the case was committed to the Court of Session, where the London Trial Court framed charge as aforesaid against the appellant, to which he pleaded not guilty and claimed to be tried, for which the sessions trial procedure was resorted to establish his guilt. In order to defense plea was one of denial. However, two witnesses were examined on behalf of the defense. DW1 is so and so, DW2 is so and so. Medical treatment file of the appellant was proved by the defense, marked as Exhibit A. अच्छा से जो ये पर exhibit पर कर दो. The prosecution also proved 3 material objects, MO1 so and so, 2 so and so, 3. The London Trial Court after analyzing the oral as well as documentary evidence, came to hold that the evidence of PW5 and PW6 regarding extrajudicial confession made by the appellant is reliable and trustworthy, which unmistakably showed the appellant to be the perpetrator of the crime. It was further observed that from the evidence of PW5 and 6, it is proved that the dead body of the deceased was recovered at the instance of the appellant from the place of concealment, that is inside the mouse hole filled with loose soil, and was not visible to others in her bedroom. The Lenin trial court further held that the incriminating articles were sent for chemical examination, and as per the C report exhibit 15, human blood was detected in all these articles, and specifically human blood of group B was detected in the bloodstained earth collected from the mouse hole and on the printed sari of the appellant. The London trial court summarized the circumstances which have been established by the prosecution to fasten the guilt of the appellant as follows. Quote from paragraph number 21. The London trial court further held that in view of the admission of guilt by the appellant as per the evidence of PW 5 and that she cut the throat of the deceased as PW 5 had a quarrel with her, it can be said that motive of the appellant has been proved. The London trial court further held that the appellant in her statement under section 313 CRPC has taken a complete denial plea. And the contention raised by the London Defense Counsel that the appellant is entitled to the benefit of section 84 of the Indian Penal Code was torn down with observation that from the acts and conducts of the appellant, it demonstrates that at the time of commission of the offense, she was not suffering from any mental illness and she was in complete sense of understanding of her acts. And accordingly, the appellant was found guilty under section 302 of the Indian Penal Code. What is your good name?
Lordship, Binny Mishra. Binny Mishra.
B-I-N-I, na?
Yes.
Ms. Binny Mishra, Land Counsel appearing for the appellant, contended that the case is based on circumstantial evidence. However, so far as the main circumstance is concerned, that is extrajudicial confession, which is deposed to by PW5, PW6 and PW9, cannot be acted upon as there is evidence on record that number of persons gathered at the scene of occurrence and the appellant was tied, and therefore it cannot be said that it was a voluntary one. The Learned Counsel further submits that the recovery of the dead body at the instance of the appellant as deposed to by the witnesses and a finding of the bloodstained earth and sickle from the room of the appellant cannot itself be a factor to find the appellant guilty of the offense charge. It is further argued that the Learned Trial Court has not considered the evidence on record properly and torn down the benefit of section 84 of the Indian Penal Code. According to Ms. Mishra, PW9 has specifically stated that prior to the incident, the appellant was suffering from mental illness and taking medicines. And the evidence of the doctor, bracket DW2, was working as a psychiatrist in Circle Jail, Baripada. And the file of the appellant from Baleswar Jail indicates that she was of unsound mind, and she was diagnosed as a case of seizure-depression, and medicines were prescribed to her. The Land Council further argued that the manner in which, without any kind of pressure from anybody, the appellant showed the place where the dead body was concealed also indicates the unsoundness of mind, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant, who is in custody since 5/4/2007. And in the meantime, 16 years and 9 months have already passed. Mr. S.K.MISHRA, an additional standing counsel, on the other hand, supported the impugned judgment and argued that the evidence on record indicates that when PW6 accompanied the appellant alone inside the room, there she not only showed the place of concealment but also removed the cauldron, the loose jar, brought out the dead body, and it was found that the neck of the child was caught. And when an inquiry was made, she made the extrajudicial confession and admitted to have caught the neck of the child by means of sickle. It is argued that the appellant was not tied at that point of time, nor any threat was given to her. She was tied afterwards, and therefore it cannot be said that the extrajudicial confession was not voluntary. It is further argued that the circumstances appearing on record against the appellant are very clinching, and the London trial court has rightly came to the conclusion that the circumstances taken together form a complete chain, and it points unerringly to the guilt of the appellant. The London Council placed reliance in the case of Bapu alias Gujraj Singh versus State of Rajasthan, reported in 2007, Volume 8, Supreme Court Cases, page 66, and argued that mere abnormality of mind or partial delusion, irresistible impulse or compulsive behavior affords no protection under Section 84 of the Indian Penal Code. And when no plea of legal insanity was taken in the accused statement, and the appellant has the onus of proving the same in view of Section 105 of the Evidence Act, and his conduct prior to the occurrence, at the time of occurrence, and after the occurrence are very relevant factor. And in the case in hand, it appears that she was behaving very normally and with all maintaining all secrecy, committed the crime and also took steps for hiding the dead body inside the mouse hole and keeping the same covered with earth and a cauldron. And then having her child in the lap shows that she was not suffering from unsoundness of mind, and it cannot be said that at the time of committing the act, the appellant was laboring under any defect of reason from disease of mind, as not to know the nature and quality of the act which she was doing, or that what she was doing was either wrong or contrary to law. And therefore, the appeal should be dismissed. Adverting to the contention raised by the learned counsel for the respective parties, let us assess the evidence on record as to how far the prosecution has established that the deceased suffered homicidal death. Apart from the inquest report marked as Exhibit 1 and the ocular evidence that the throat of the deceased was cut deeply, Dr. Vijay Ketan Das, PW10, who conducted post-mortem examination over the dead body of the deceased on 5/4/2007, noticed one lacerated wound surrounding almost whole neck, extending through cervical vertebra up to posterior part of the skin of the neck, left only lag of skin about 2 inch posteriorly. He opined the cause of death was due to injury to the vital organ like esophagus, trachea, and great vessels, followed by hemorrhagic shock. He further opined that the time since death was within 6 to 12 hours of his examination and proved the postmortem report marked as Exhibit 7. The investigating officer produced one sickle which was seized from the spot before the doctor for examination and opinion. And after examining the sickle, PW10 gave his report that the injury noticed on the dead body of the deceased was possible by the sickle, and the query report has been marked as Exhibit 8. Nothing has been brought out in the cross examination of the doctor, and in fact, neither during the before the trial court nor before this court any point was raised disputing the homicidal death of the deceased. In view of the available material on record, particularly the inquest report, the ocular evidence, the postmortem report findings, we are of the view that the London trial court has rightly came to the conclusion that the deceased met with homicidal death. The appellant's presence in the vicinity at the time of occurrence is deposed to by PW5, who has stated that the appellant asked for tobacco and she gave her tobacco, and when she was inside her house, the appellant went to her house taking tobacco from her. The evidence of these three witnesses to extrajudicial confession, that is PW5, PW6, and PW9, is required to be discussed here. Law is well settled that extrajudicial confession is a weak piece of evidence, and the prosecution has to prove that it was a voluntary one, and there was no element of any kind of inducement, threat, or promise to the accused for making such confession. In the case in hand, PW5 has stated that when she found her daughter missing from the cattle, it was about 7:30 to 8 a.m. And at that point of time, the appellant was sitting in her veranda adjacent to her house, or bracket like the PW5's house. And she inquired the matter from her, but she denied her knowledge. And then she called her Bodoja, Arati Pradhan PW6, who searched for the child. PW6 suspected the appellant, and on query, the appellant went inside her house and showed the child. Was kept inside the mouse hole, and the neck was cut, throat was cut. She further stated that when PW6 inquired from the appellant to know about the cause of incident, the appellant disclosed that she cut the throat of the baby. As PW5 was quarreling with her, it has been elicited in the cross examination that the appellant was having two daughters and one son. And when PW6 went inside the house of the appellant to search for the deceased, she did not accompany her. In the cross examination, PW5 further states that when the appellant admitted to have cut the throat of the deceased, she was present along with other persons, about more than 50. She stated that she could not say whether the appellant was in a dying condition. PW6 on the other hand stated that when she was informed by PW5 about the missing of the deceased from the cradle, she searched for the baby and inquired from the appellant. And then the appellant went inside her bedroom and she followed. And inside the room, the appellant showed a place where a cauldron was kept, and underneath that there was some loose earth, and the appellant in her own hand removed those loose earth and brought out the dead body of the deceased and it was found that the neck of the child was cut. And when she inquired about the cutting of the neck of the child, the appellant admitted to have cut the neck by means of a sickle. She further stated that the appellant was about to go away from the room, but the persons assembled outside detained her. In the cross-examination, she has stated that 4 to 5 times she loudly asked the appellant about the daughter of PW5. The learned counsel for the appellant submitted that by making such statement, uh, it would indicate that the confessional statement by PW5 was not a voluntary one. Confessional statement by the appellant was not a voluntary one. We are not inclined to accept such submission because there is no evidence of any compulsion, threat to the appellant at that point of time. PW6 in her cross-examination has stated that she accompanied the appellant alone inside the house. However, it stated that however, it has been confronted to her and brought out through the investigating officer that she has not stated that the appellant was trying to go away from the spot. She further stated that the persons present there tried the appellant and when the appellant admitted to have cut the throat of the deceased, other persons outside the room had seen her admitting the guilt. Therefore, there is nothing to disbelieve the evidence of PW6 so far as the extrajudicial confession part is concerned. PW9 Umakanta Pradhan has stated that when the search was made for tracing out the missing baby from the cradle, and the appellant was also confronted. First, she was reluctant to give any reply, and on being repeatedly asked, she confessed to have murdered the deceased by cutting her throat by means of a sickle and put the dead body of the deceased inside the mouse hole in her bedroom. And then the appellant went to her bedroom and in their presence brought out the dead body of the deceased from inside the rat hole, and it was found that the deceased had sustained cut injury on her throat. In the cross-examination, he has stated that when the dead body was brought out by the appellant, 10 to 12 persons were present, and some outsiders, except apart from the family members, were also present. The evidence of PW9 that prior to entering into the room, the appellant made extrajudicial confession is not getting corroboration from the evidence of PW6. Inasmuch as PW6 has stated, it is only after the appellant entered into her bedroom, showed the place, removed the cauldron and the loose earth, brought out the dead body, then she made the confession to her. अब बांधिवा विषय ଆଉ କିଏ କହିଛନ୍ତି କି?
PW3.
କୋଉ ଲାଇନଟା କହିଲେ?
In the cross examination, page 44, your lordship, the last line. Paragraph 4.
PW3 has stated that when he reached the spot, he saw a gathering of 100 persons, and the appellant admitted her guilt in presence of the mob, and after confession, the appellant was tied. This statement given by PW3 cannot be a factor to discard the evidence of PW6, before whom alone the appellant had made extrajudicial confession inside her bedroom after detection of the dead body. Therefore, we are of the view that the Lennon trial court has rightly placed reliance on the evidence adduced by the prosecution relating to extrajudicial confession. In as much as the appellant was tied much after she made the confessional statement before PW6, and at that point of time, there is no material that she was threatened or there was any kind of inducement, promise to not to place reliance on the same. The recovery of the dead body from the place of concealment, that is from inside the rat hole in the bedroom of the deceased, at the instance of the appellant, is another factor which goes against the appellant, and the same has been deposed to by PW5 and PW6, and nothing has been brought out in the cross-examination to disbelieve such aspect. Similarly, it has also been proved that one sickle with bloodstain was lying inside the bedroom, which was seized by the investigating officer and sent to the doctor who conducted post-mortem examination, who opined that the injury on the throat of the deceased was possible by such sickle. Moreover, when the sickle was sent for chemical examination, the report has come by the Exhibit 15 that human blood was detected on the sickle. Of course, no opinion was given about the blood grouping. The scientific team, as well as the investigating officer, have also proved the seizure of there was bloodstain mark on the floor of the bedroom of the appellant, and on the sari of the appellant, and the C report indicates that the bloodstain earth was found to be containing human blood and was of group B, and the printed sari of the appellant was also containing human blood of group B. Therefore, the prosecution has established the following materials: that the deceased was missing from the cradle where she was placed, and the appellant was nearby. The appellant made extrajudicial confession before her relations to have committed the murder. The dead body of the deceased was recovered from the place of concealment, that is, from inside the rat hole in the bedroom of the deceased at her instance. The weapon of offense, that is sickle, which was bloodstain, was also found from the bedroom of the appellant. The bloodstain mark was also found on the floor of the bedroom, and there was bloodstain in the sari of the appellant. The deceased met with an homicidal death, and the human blood of group B, which was found on the floor of the bedroom of the appellant, was also there on her sari. Therefore, it can be said that in the factual scenario, the circumstances which have been established by the prosecution form a complete chain, which unerringly point towards the guilt of the appellant. Now the question crops up for consideration as to whether the appellant is entitled to get the benefit under Section 84 of the Indian Penal Code or not. It is pertinent to point out that in his examination under Section 313 CRPC, the appellant never raised a plea of insanity. However, since absence of a specific plea does not debar an accused from raising such a plea on the basis of materials brought on record, we have to entertain and record a finding on that plea. Section 84 of the Indian Penal Code does not confer immunity from criminal liability in every case of insanity of the accused. Along with the insanity, there must be proof of the fact that at the time of commission of the act, the accused was laboring under such a defect of reason from disease of the mind that he was incapable of knowing the nature of the act, or what he was doing was either wrong or contrary to law. The mere fact that on earlier occasions the accused had suffered from mental derangement will not be sufficient to bring his case within the exemption of Section 84 of the Indian Penal Code. To put it differently, it must be shown that the mental faculty of the accused were, as a result of unsoundness of mind, so completely deranged as to render him incapable of knowing the nature of his act, or that what he was doing was either morally wrong or contrary to law. To arrive at such a conclusion, it is therefore necessary to ascertain the behavior antecedent, attendant, and subsequent to the event that may be relevant in finding the mental condition of the accused at the time of event, but not that remote in time. It is difficult to prove the precise state of offender's mind at the time of commission of the offense, but some indication thereof can be ascertained by assessing the conduct of the offender while committing it or immediately after the commission of the offense. These behaviors are not conclusive, but they certainly provide an insight to the mind of the offender. Mere absence of motive for a crime, however atrocious, cannot, in the absence of proof of legal insanity, bring the case within the ambit of Section 84 of the Indian Penal Code. In medicine, there are many kinds of insanity, but in law, insanity is of two kinds. That is, one, we should exempt the person is destroyed as a result of unsoundness of mind to such an extent as to render the offender incapable of knowing the nature of the act, or that what he was doing was contrary to law. In the case in hand, as it appears that when the offense was committed, nobody was there near the place of occurrence, and the deceased was sleeping in the cradle. And the possibility of committing the crime in a secret manner is not completely ruled out, and the further steps taken by the appellant in keeping the body in a hidden manner inside the mouse hole are also relevant factors, which is to be taken into account while considering the legal insanity aspect. Though PW6 has stated that the appellant was trying to go away after making the confession, but the same cannot be accepted as the same has not been deposed to, or same has not been stated in our previous statement recorded by the investigating officer. PW9 has stated, so also in her examination in chief, PW9 has stated that 1 year prior to the incident, the appellant was suffering from mental illness and taking medicine. Of course, another witness, PW6, has stated that the appellant was not suffering from any disease, either physically or mentally. The appellant was having 3 children, and the motive behind the commission of crime, as stated by PW5, ना किए कहला से जो पार रही थी लेवल
5 Your Lordship. The mother of the deceased.
PW5, that the appellant stated to have committed the crime as PW5 was quarreling with her, is not deposed to by the other witnesses to the extrajudicial confession. And therefore, it cannot be said that there was any particular motive on the part of the appellant to commit the crime. When the appellant was forwarded to court, she was examined by the jail medical officer, and it was found that she was behaving abnormally and she was not taking meal, behaving abnormally, and not keeping her clothes. The medical officer contacted the psychiatrist of the jail, who has been examined as DW2, who has stated that on receiving such telephone call, she advised to treat the appellant by giving antipsychotic medicine till her visit. She further stated that when she visited Baleswar jail and examined the appellant, she diagnosed it is a case of schizodepression, and she gave a treatment for which she gradually improved. She further stated that the symptoms which she found on the date of her examination were likely to be present earlier prior to her examination, and the duration may vary from 1 week, 1 month to 1 year. And the appellant was suffering from seizure depression, and features of schizophrenia and depression were found. And when she examined, she was under hallucination and paranoid delusion. And as per the above symptoms, she was partially but grossly impaired in respect of her judgment and perception. She further stated that if the treatment is discontinued, then there was a chance of recurring her earlier symptoms. In the cross-examination, she has stated that when she examined her, she was crying, she was sleepless, and she was refusing to take food and insisting to go home. The medical file of the appellant has been marked as Exhibit A, in which the medicines which are prescribed from time to time have been mentioned. In view of the available material on record, we are of the view that even though a specific defense plea regarding unsoundness of mind has not been taken by the appellant, but in view of the evidence of PW9 and evidence of the two defense witnesses coupled with the medical file Exhibit A and absence of any specific motive on the part of the appellant to commit the crime, and the manner in which silently pointed out the place where the dead body was concealed to PW6, we are of the view that the from the behavior antecedent, attendant, and subsequent to the event, it appears that the appellant has is liable to get the benefit of Section 84 of the Indian Penal Code. And therefore, the criminal appeal is allowed. The conviction of the appellant under Section 302 of the Indian Penal Code is hereby set aside. The appellant is now lodged in District Jail, Baleswar, and she shall be treated at if there is any active symptoms at Fakir Mohon Medical College and Hospital, Baleswar. And for other therapies, the psychiatrist appointed in the jail shall be consulted. And the appellant shall be kept under his treatment until she is certified to be mentally fit by the doctor. It is open to any of the family members and relatives of the appellant to move the London trial court to deliver to him/her. If such a motion is made, the same shall be considered, keeping the welfare of the appellant in view. Put a note of appreciation on the efforts of Ms. Bini Mishra and Mr. Mishra. Yes.
May I beg to pardon, my lord? On bail matter, similar co-accused person has been released on bail.
Yes.
Then 6 months. That was in the list of 5th January. That was
Yes.
SC/ST appeal.
My lord, one IA has been filed for interim bail. Out of 10 years, has already been spent. May I pray the matter to be taken? Because earlier also mentioned, but
Please
the
give it, it will come next week.
Monday.
Lordship is a urgent bail matter.
Give it.
The tie of bail matter, your lords.
Your lordship,
My lords, I for bail in a post conviction matter, sir. And my lords for a SC/ST bail matter, criminal appeal.
Give it.
Tired of bail matters.
your lordship, please, your lordship,
Bail matter.
Please give it.
please, your lordship,
Yes. Sir.
please, may I please, your lordship.
Yes.
Lordship, specific adjournment, it was listed on 31st January, 19 January 2024. So may we letter be listed on Monday, your lordship.
What is the number, please tell?
BLAPL number 14538/2023. It is specifically adjourned on 19th, your lordship.
Okay. Yes. Yes.
My lord, I may be excused, my lord.
Yes.
My lord, I am from Denkanal BC, my lord.
Yes.
Bail application 10967.
Number.
What
is the number again? Please tell once again.
10967, my lordship. 10967.
Of
It may kindly be listed in next week.
of which year? 2023.
23, my lord.
Okay.
My
All
lord. Problem, my lord.
Supplementary list, item number 1.
May I please, your lordship? Your lordship already had this matter. He was faced trial under section 302, 304B, 498A with 34 of IPC. But ultimately convicted under section 306 of IPC and 498A and directed to imprisonment for a period of 5 years under section 306 and for 2 months under section 4 of DP Act and 3 years under section 490. Now, the two important witnesses, Your Lordship, is PW8, is the doctor who said that I cannot say whether the death was accidental, suicidal, or PW8, CPS 68, Your Lordship.
Yeah.
Page 70 day, as the body was severely burned with charring, it was not possible to say definitely whether it was accidental, homicidal, or suicidal in nature. However, the opined that the burn was antemortem in nature. No injury remaining parts of the skin or deeper soft tissue or any fracture dislocated could be found from the body of the deceased. This is the opinion of the doctor, and another is PW7, the brother of the deceased. He categorically stated that just before 1 day before the death, he went to his sister's house and found the there was a normal, there was a PW7, Your Lordship. PW7 କହୁଛି ମୁଁ ତା ଆଗ ଠିକ ତା ଆଗ ଦିନ ମୁଁ ତାଙ୍କ ଘରକୁ ଯାଇଥିଲି, ସେଟା କଣ୍ଡିସନ ନର୍ମାଲ ଥିଲା। Para 3 on the next day
no, see, he stated about that there was a demand of scooter.
It was 7 years back, Your Lordship.
For that,
7 years back, ସେତେବେଳେ ଯେତେବେଳେ ବାହାଘର ବେଳେ ସେ ଗୋଟେ ସ୍କୁଟର ମାଗୁଥିଲା, ସେତେବେଳେ ସେମାନେ ଦେଇନଥିଲେ, ସେଇଥିପାଇଁ ସେ ଟିକେ ଗଣ୍ଡଗୋଳ ଥିଲା ବୋଲି ସେ କହୁଛି। ତା ଆଗ ଦିନ କିନ୍ତୁ ସେ ଯାଇଥିଲା ତାଙ୍କ ଘରକୁ।
He said, okay, on that day the accused husband was present. We stayed कोई दिन की
Para 2 रे
I
कହୁଛି
along with my so went to 1 day prior to this one. 1 day prior to the death of the deceased and gave all those things.
We stayed there for an hour and come back. On the day the accused Lakshman was present in his house, I saw my sister who was shifting grains from the chaffs, and I talked to her, and staying for a moment, I came back.
Okay.
The prosecution is saying it was a case of suicide because a bottle of kerosene was seized from the cow shed. He was found born in the cow shed. One dead body was found in the cow shed. No eyewitness was there. 304B was not there because the marriage was after 7 years. That was ruled out. The ସେଠି ଗୋଟେ ଖାଲି ବଟଲ ଅଫ କିରୋସିନ ଟା ସିଜ୍ ହେଇଥିଲା ବୋଲି ସେମାନେ କହୁଛନ୍ତି ଯେ ଏଟା ସୁଇସାଇଡ ହେଇଥିବ।
Two bottles were seized, Lordship. On the last occasion we verified, and Lordship, it was as per Exhibit 8, 2 bottles were seized, my lords. One was half full and one was completely empty, and one matchbox was also found at the spot.
କିନ୍ତୁ ଡକ୍ଟର କହୁଛନ୍ତି no smell of kerosene from the dead body. ଡକ୍ଟର ତାଙ୍କ ଏଭିଡେନ୍ସ ରେ କହୁଛନ୍ତି I found no smell of kerosene. Categorically କହୁଛନ୍ତି।
No, again it depends upon, you see, if medical evidence is silent about the exact nature of death, then the court has to look into the circumstantial evidence. So the spot verification note, the scientific team's opinion, what the witnesses have stated that how the body was found, and what were found near the body, those are very relevant factors. Cannot say that merely because doctor says was no opinion could be given.
Like ସେଠି ପଚାରୁଛି no smell of any chemical like kerosene as found. ଲେଖା ହେଇଛି
No smell of kerosene. Suppose somebody has burnt herself with kerosene, and the body is completely burnt. Question is that whether in such a circumstance kerosene smell would come out or not.
That is Modi jurisprudence ସେଟା କହୁଛି।
And
मोदी
He-
jurisprudence रे गोटे
how many days after death she was subjected to postmortem examination?
same day same day गोटे दिन पर
Occurrence day केबे तो
से मोदी jurisprudence को burn caused by kerosene oil are usually very severe and are known from its characteristic odor and the scutty blackening of parts.
Date of occurrence होची 14/3 सप्ताह लगे
आज्ञा 15/3/97 रे ହେଇଛି
कौन?
पोस्टमार्टम पोस्टमार्टम 15/3/97
देखिए मोदी jurisprudence कौन टा अछि कौन भाग कर born injury और chapter टा केते को chapter अछि
chapter 22
chapter 22 हाँ
20 पोस्टमार्टम अपीयरेंस होता है सेथिरे
postmortem appearance
आज्ञा
external
एक्सटर्नल तापर से गोटे सेपट 629 पेज रे अछि बर्न्स caused by kerosene
काई
बस सेकंड थर्ड फोर्थ पारा
हाँ
फोर्थ पारा रे जोटा लिखा होछि
से
गोटे लाइन खाली
से postmortem year heading रे
आज्ञा पोस्टमार्टम अपीयरेंस रो हेडिंग रे एक्सटर्नल आगे लिखा है तापरे फर्स्ट
burns caused by kerosene oil are
usually very
usually severe and are known from its characteristics odor and sooty blackening of the parts.
That second part has been found, Your Lordship. Although the order was not found of kerosene, Lordship may take page 69, second paragraph of the postmortem report. On dissection, I found the follows. Trachea contained black shoot particles.
ସେଇ ଯୋଉ ଅଙ୍ଗାର ଗୁଡାକ ନାକ ଭିତରେ ପଶିଯାଏ ଆଉ ସେଗୁଡାକ ଚୋକ୍ କରିଦିଏ ଯୋଉଥିପାଇଁ ସେମ୍ ଥିଙ୍ଗ ଯୋଉ ଯେତେବେଳେ କୌଣସି ଜାଗାରେ ବି ନିଆଁ ଲାଗିଯାଏ ସଫୋକେସନ ଆସିକିନି ମଧ୍ୟ ଧୂଆଁରେ ସଫୋକେସନ ବର୍ନ ଇଞ୍ଜୁରି ଥିବ କିନ୍ତୁ ଡେଥ୍ ହେଇଥିବ ଅନ୍ ଆକାଉଣ୍ଟ ଅଫ ସଫୋକେସନ କି ଗୋଟେ ବାହାରିବାକୁ ଚେଷ୍ଟା କରୁଥିବ ଗୋଟେ ଘର ଭିତରୁ ସେତେବେଳେ ବି ନିଆଁ ଲାଗିଯାଏ ସଫୋକେସନ ହୁଏ ସେଗୁଡାକ ବି ହୁଏ ବଟ୍
no evidence of any mark of violence fracture of dislocation could be found
violence कोन हो जदी सुसाइड कला violence तादर कोड आछो से निजे जदी पोड़ी किनी मरला तब किना कि जबरदस्ती ये करथले किछि आस्थांता कि स्पॉट रे वायोलेशन आस्थांता से चेष्टा करथाना निजु बंचिया को
एटी जो एक्सीडेंटल डेथ तक भी रूल्ड आउट करि नांदी
एक्सीडेंटल डेथ सेट केमति हो एक्सीडेंटल डेथ ले गोटे घर पोड़ीची हां जणे थिला ता देहर पोड़ी गेला हां जणे जेतेबेले देखाउची गोटे जागा रे गुहाळाटा भितरे गुहाळाटा पोडुनी ता सी बॉडी किन पड़ीची ता पाखरे किरोसिन दीटा बोतल पड़ची आउ येटा पड़ची सेटा एक्सीडेंट रो कोठ आसीबो
जदि गुहाळटा रे लाइन फाइन नथिबो इलेक्ट्रिसिटी नथिबो गुहाळटा रे जाइथिबो लगे पे डीबीपी लगे पे जाइथिबो सेठी एक्सीडेंट
अरे जदि एक्सीडेंटल आसी दौड़ीबो ना सेठी छिड़ा हितो निजु बंचिया पई चेष्टा करे धर एक्सीडेंटल हेला पानी निजु ढाल दे सेठ दौड़ी किन का चित्कार करे सब करिवो ना सेठी रहिथिबो मु पड़ी जाय तापरे मरि गला पर अन्य माने आसी देखिबे Think of the situation, what would happen in case it is an accidental one.
In case of also suicide, your lordship, तार गोटे पुओ भी मरी जाइथिला किछि दिन आगुरु आ तार फैमिली प्लानिंग ऑपरेशन हे जाइथिला.
No, merely because it is, let us say circumstance established that it's a case of suicide. That would not itself be a factor to convict the accused under 306 unless there is any proximate link between the conduct of the accused with the suicide.
सेही तो आपण कहथिले प्रॉक्सिमिटी लिंक ऊपर किछटा जजमेंट आनिया पे. That's a come up with judgments, your lordship.
A person may commit suicide for several reasons. So if only for this reason or any kind of behavior which was meted out to her by the appellant that she decided to end her life, the torture was of such a magnitude, she thought that living in this world would be meaningless for me, and nobody is liking me, my life has been spoiled in this way. So she decided to end of her life. Then the person who is responsible for that can be said to have abated the commission of suicide. Then he can be
proximity link रहुनी कारण ता आग दिन जाइथिला ता भाई ता घर को आ से नॉर्मल सिचुएशन थिला करे.
आग दिन भाई जो समय रही से समय किसी अघटन हेनी, मैक्सिमम एतिकी आसी परिबो.
हां
ता माने नुहे
चुपचाप बसिकी
हां से काम करूथला भाई पाखरे किसी कंप्लेन करनी अक्यूज ना रे हला कि ये किसी सेमती घटना देखिनी जो थ्रू की जना पड़िबो जे शी वाज इन एनी वे अनकंफर्टेबल इन हर इन लॉज हाउस और शी वाज इन ए डिप्रेस्ड स्टेट सेटा आसुनी. Mr. Mishra,
Lordship.
Let us say that from the circumstantial evidence, even the medical evidence is otherwise, that no kerosene smell was found and Modira jurisprudence. So you are to again establish that the conduct of the appellant is linked with that suicide. Then only you can establish the charge. That's why number of decision they have stated about the proximate link.
Lordship.
ତେଣୁ with ଅନ୍ୟ କ'ଣ କାରଣ ଆପଣ ଯଦି it is your duty to establish, prosecution duty. ଯଦି ଆପଣ ସେ ଲିଙ୍କ ଟାକୁ ଏଷ୍ଟାବ୍ଲିଶ କରିପାରୁନାହାନ୍ତି ତାହେଲେ ଆପେଲାଣ୍ଟର ଘରେ ତା ସ୍ତ୍ରୀ ସୁଇସାଇଡ୍ କଲା ଏତିକି ଯଦି ଏଭିଡେନ୍ସ ଆସେ, can it be said that it is the appellant who is responsible for that?
No, in such a scenario it cannot be. But
then what evidence you have adduced to prove that he is responsible for the suicide?
My lords, my contention is that there is continuous direct or indirect acts, your lordship.
ସେ କହୁଛନ୍ତି ପରା ସେ ଯୋଉ ସ୍କୁଟର ଡିମାଣ୍ଡଟା ହେଇଥିଲା ସେଇଟା ସେ ବାହାଘର 7 ବର୍ଷ ତଳେ ହେଇଥିଲା ନା, ସେତେବେଳକୁ ହେଇଥିଲା ସେଇଟା ସେ ସିଚୁଏସନ ପାସ୍ କରି ଯାଇଥିଲା ଅଲରେଡି. ତାଙ୍କ ପିଲାପିଲି କେତେଟି? ତିନିଟା ପିଲା.
ଦିଟା ଝିଅ ଗୋଟେ ପୁଅ. ପୁଅଟା
anybody has stated that till the death that demand was still continuing, there was again torture from the side of the appellant to the deceased in that connection. କାରଣ ବାହାଘର ବେଳେ ଯେତେବେଳେ ଗୋଟେ ଜିନିଷ ହେଇଥିବ ତାପରେ 7 ବର୍ଷ ପାସ୍ କଲାଣି, 3ଟା ପିଲା ହେଲାଣି, ତେଣୁ ଗୋଟେ ପଏଣ୍ଟ ଅଫ ଟାଇମରେ ତାଙ୍କ ଭିତରେ ହୁଏତ କିଛି ଡିସେନସନ ଥାଇପାରେ, ସେଇଟା ସବସିଷ୍ଟିଂ କରୁଥିଲା as on the date of occurrence. Evidence କାହିଁ?
No, that precise not there.
That even if you fail to bring that, then that proximate link is getting failed, and if that is getting failed, then 306 fails.
That's two other circumstances are there, my lords. The evidence of PW, as per evidence of PW 1 and 6, there was no peaceful living of their daughter with their son-in-law, your lordship, and they used to
So,
quarrel
দেখুন
very.
একটু point out করুন।
Lordship, PW1, my lords, page
Hmm.
47.
Admittedly, marriage took place 7 years prior
7
to
years
this.
back, yes.
That was the reason why he was acquitted. He was acquitted of the charge under 304B.
My lords.
7 years পূর্বରୁ ହେଇଥିବା ଅଛି। Then could have କୁହନ୍ତୁ।
Lordship may take the 6th line from bottom, page 47.
47.
My lords.
After marriage.
Lordship, after marriage, my daughter was sent to her in-laws' house, but she had no peaceful living there.
Hmm.
On all days, there was quarrel and misunderstanding of the deceased with the in-laws of my daughter.
Hmm.
Sometimes she was assaulted by them. Accused Laxman was also assaulting the deceased. Accused Hiralal was also insisting my daughter to bring the scooter. Hiralal has been acquitted, your lordship.
Hmm.
When the deceased used to come to our house, she was telling
Hiralal
about
କିଏ ମାନେ ଆଙ୍କର
brother-in-law, ସେ
Brother-in-law.
acquittal
ମାନେ ଭେଣେଇ ହବ
ବଡ
ନା
ଦେଢଶୁର
ଦିଅର
ଦେଢଶୁର।
ଦେଢଶୁର ଅଛି। Yeah.
When the deceased daughter used to come to our house, she was telling about the assault and ill treatment to her.
Hmm.
In the month of March of the occurrence year,
Hmm.
while my daughter was in our house, accused Laxman came
Hmm.
and threatened my daughter to go with him, otherwise she would be assaulted. Out of fear, we sent our daughter with him to her in-laws' house.
Hmm.
After her departure on 13/3/97, we sent our son Chandan Chura and his friend to the in-laws' house of the deceased.
ଚନ୍ଦନ ଚୂରା କେତେ ନମ୍ବର ସାର୍?
PW7.
7 ଜି ତା ଭାଇ।
ସେଇ ଯୋଉ ବସିଥିଲା ଯିଏ ଦେଖିଲା ଯୋଉ
ଆଜ୍ଞା।
ତାର-
Lordship, lordship.
ଓକେ ଆଉ
ଆ-
ବାକି ସେ ଯୋଉ ସାଙ୍ଗଟା
ସାଙ୍ଗଟା ଏଥିରେ ହେଇନି ବୋଧେ।
ଆଜି ଫ୍ରେଣ୍ଡ କହୁଛି ପରା ଏକ୍ସାମିନ ହେଇଛି ନା ନାଇଁ?
ନା ସେ ଆଉ କେହି
ମାନେ PW7 ର ଗୋଟେ ଫ୍ରେଣ୍ଡ ବି ଯାଇଥିଲା।
No, he has not been examined, madam.
ହଁ PW7 କହୁଛି କି ତା ସାଙ୍ଗ ତା ସାଙ୍ଗରେ ଯାଇଥିଲା ବୋଲି। ହଁ I along with my friend ଭରତ କହୁଛି। ଭରତ ଏକ୍ସାମିନ ହେଇନି? ପେଜ ନମ୍ବର 66 paragraph number 2 second line।
Lordship, my friend Bharat, yes.
ସେ ଭରତ ଏକ୍ସାମିନ ହେଇଛି କି?
No, your lordship has not been examined.
Okay. So अच्छा तापर से कौन कोइला?
Lordship.
And after talking with the deceased returned to us. So even when PW7 returned back after giving those articles, this PW1 has not stated that PW7 complained against any of the family members, particularly against the appellant.
No such evidence.
So there is no such evidence.
ସେ IOB କହିଛନ୍ତି I have examined PW1. She has not stated before me that while her daughter was in their house, accused Lakshman Suna came there and my daughter to go with him. Otherwise, she will be assaulted. Out of fear, they sent their daughter with him in the house, and that she was not stated before me that hearing the death of the deceased, she cried and other.
ସେ ଯୋଉ confrontation ହେଇଛି ତାର previous statement ଗୁଡାକ ସେଇଟା paragraph 9 ରେ confront ହେଇଛି। যেগুଡାକ ସବୁ ପୋଲିସ ପାଖରେ କିଛି କହିନ
8 ଆଉ 9
ଏଇଟା କେତେ
PW1 1 para 8 ରେ confrontation ହେଇଛି।
ନାଇଁ ନାଇଁ paragraph 9 ରେ
Para 9
confront ହେଇଛି।
PW1.
ତାକୁ ପ୍ରମାଣିତ ହେଇଛି କାହା ଦ୍ୱାରା ଜରିଆରେ?
That IO has, your lord.
IO ଟା କେତେ ନମ୍ବର ଚାକିରି?
IO is PW9, madam.
9
PW9 ସେ ଯୋଉ confrontation ଟା prove ହେଇଛି କୋଉ paragraph ରେ?
paragraph 8
Para 8, your lord. Page 75.
ଦେଖିବା ଟିକେ page 75
my lord.
75 ହଁ I have examined ଆଚ୍ଛା ପଢିଲେ ସେଟା
I have examined PW1. She has not stated before me that while her daughter was in their house, accused Lakshman Suna came and threatened my daughter to go with him, otherwise she would be assaulted. Out of fear, they sent their daughter with him to her in-laws' house, and that she has not stated before me that hearing the death of the deceased, She cried and others came, and thereafter her son, along with his friend,
ଛାଡି ଦିଅନ୍ତୁ ତାହେଲେ ଏଇ ପାର୍ଟଟା ସେ କହିନି
Lordship,
ତେଣୁ ଏଇଟା ଆସୁଛି soon before the
incident.
occurrence
My
or
lords.
soon ଯଦିଓ ନୁହେଁ ତଥାପି ମାସେ ଭିତରେ ଘଟଣାଟା ମାନେ ଇଏ ହଉଛି ସେଇ ପାର୍ଟଟା ସେ କହିନି ବାକି ସେ ଯାହା କହୁଛି ସେ କମ୍ପ୍ଲେନ କରୁଥିଲା assault ଆଉ ill treatment ଏ ବିଷୟରେ କହୁଛି
This same incident which PW1 has stated, which she has stated to have taken place in March, my lords, PW6, who is the father, your lordship, he has also stated that.
এইটা হচ্ছে PW1 কি
Mother, my lords.
just a minute
PW6 is the father.
father father হচ্ছে PW6
My lords. But he has stated that this exact occurrance took place in the month of January, my lords, of that very same year. And this has not been rebutted by the defense.
PW6
My lords. Lords, you may take page 59.
59 কোটা
My lords, the third paragraph, lordship, the fifth line from the bottom. Sometime after. Sometime
in 1997 acha
my lords.
in the
Lordship,
month of
may I please just a little before that, in 3 lines above that, in the following. In the following December, my daughter was sent to her in-laws' house. Then in the year 1997, in the month of January, once again my daughter with my granddaughter came to our house. Sometime after, accused Laxman came to our house and asked my daughter to go, who did not agree. And thereafter, accused Laxman threatened to assault if she would not go with him. For this, we sent our daughter back to her in-laws' house. So this same incident, your lordship, the father is stating it took place in January, and this has not
now
been
this
rebutted.
statement which has been given in paragraph number 4
My lord,
you see about this PW7 going there and returning সেটা পড়লে
my lord, in the following March, as per my suggestion, my son Chandan went
this
to
PW7
the PW7, my lord, went to the in-laws house of my daughter with clothings and bhara on 13/3/97 and returned giving those articles at about evening after taking food. On the next day, that is on 14/3/97, I went to school for my duty. At about 1:30 p.m., I was sent for by 2 persons who informed me that my daughter has died due to burning in the village Darlipalli.
so both the parents that is PW1 and PW6 they have not stated that after visiting the deceased PW7 their son made any complaint against either this accused or any of the in-laws family member of the deceased to have torture or any kind of complaint at least made by the deceased before him regarding any kind of ill treatment ତେଣୁ ଏଇଟା ଯଦି ନାହିଁ ବାକି ରହିଲା ଏଇ ଯୋଉ threatening ପାର୍ଟଟା ତ ଜଣେ କହୁଛି ମାର୍ଚ୍ଚରେ ଆସିଥିଲା ଆଉ ଜଣେ କହୁଛି ଜାନୁଆରୀରେ ଆସିଥିଲା ସେଇ ତା ଉପରେ କିଛି ପ୍ରଶ୍ନ ପଚରା ହେଇଛି ଜେରାରେ ଏଇ ଯୋଉ ଜାନୁଆରୀରେ ଆସି threatening ଦେଲା
କିଛି ପଚରା ହେଇନି
Yes, he has also been confronted, your lordship. Page 63. Page 63, paragraph number 12. Lords, the fifth line from the bottom. It is a fact that I have not stated in my FIR, nor before the police regarding...
ଆଚ୍ଛା ଏ ମାନିଗଲା ପରା ଆଉ confrontation ଦରକାର ନାହିଁ it's a fact that I have not stated in my FIR nor before police regarding the coming of my daughter to the house in the month of December and her unwillingness to so and so in the month of January 1997. I was not present in my house when my daughter was unwilling to go to so and so. It's not a fact that after so and so.
ଆଉ ଗୋଟେ ବି ପାରା 10 ରେ ଗୋଟେ କ୍ରସ ରେ କହୁଛି ଯେ accused Lakshman has not personally demanded scooter from me after marriage because the agore line goes, it is a fact that I have not stated in the FIR and before police regarding the motive of accused Lakshman for second marriage, not expecting another issue through deceased after tubulotomy operation.
ଘର ଲୋକ ଭିତରେ 1 ନମ୍ବର 6 ନମ୍ବର ଆଉ 7 ନମ୍ବର ଏଇ 3ଟା ସାକ୍ଷୀ ନା ଆଉ କିଏ?
ନାଇଁ ସେତିକି।
1 ନମ୍ବର ହେଲା ମା, 6 ନମ୍ବର ହେଲା ବାପା ଆଉ 7 ନମ୍ବର ଭାଇ। About how the deceased was found in that cow shed, who has stated? You made a submission that 2 kerosene bottles were found.
Well, it's the IO has stated, Your Lordship.
Let us see that.
The IO has actually stated that 1 bottle was found, but on verification of Exhibit 8,
when she was found in a dead condition,
Lordship,
in that cow shed, that has been deposed to by which witness? Or she was taken to the hospital and declared dead there?
So cow shed रे मर जाइଥିଲା. I dispatched the dead body to SD hospital, Patnagarh for PA examination of dead body. Channel number 80.
PW6 as stated in page number 60.
Lordship.
1, 2, 3, 4, 5, 6th line. Then I went in a scooter with Jyoti to that village. After reaching the village, on my asking as to where the deceased was lying, I was informed that she is lying in the cow shed. On my going inside the cow shed, I found my daughter lying dead. Others were also coming to see her. I found that there were burn injury in some of the places of her body, but her hair of the head and the feet were not burnt. Seeing this condition, I suspected that she has been killed by someone. From that place, myself and Jyoti went to Belpada police station in a scooter, and there I lost her. ये जोटा कहला आईओ PW9
My lords.
जो किरोसिन बॉटल जब्त कला
Lordship.
ब्रोकन बैंगल्स और मैच बॉक्स जब्त कला को जगह रु जब्त कला Exhibit 8 is the seizure list. Seizure list exhibit.
That he has stated one kerosene bottle, but the exhibit shows that there are two bottles.
No, exhibit 8 रे देखा जो place of seizure टा कोड़ा एटा 3 तापरे 7 तापरटा हाँ exhibit 8 होची place of seizure होची cowshed of Lakshman Suna. Okay. जबत ହେଇଛି गोटे काच बोतल रंग धूसर जईरे अधारू अधिक किरोसिन तेल भर्ती होइथाय आउ द्वितीय नंबर होची गोटे धला रंगर काच बोतल खाली थाय 3 खंड नाली रंगर चूड़ी आउ 4टा होची गोटे मैचिस काठी जईरे अधारू अधा स्वांशो थाय. So the dead body was found in the cow shed and inquest ମଧ୍ୟ ଦେଖଉଛି inquest cow shed ରହିଛି. Place where the body was found, inquest report column number 3. ମୁତଫି ସୁଆଣସୋ ଗ୍ରାମର ଲକ୍ଷ୍ମଣ ସୁନାର ଘରର ଉତ୍ତର ଦିଗରେ ଥିବା ଗୁହାଳରେ ମରି ପଡ଼ିଥିବା ପାୟାଗଲା. ତେଣୁ death has taken place in that cow shed and these were the articles which were found. ଲେଖା ହେଇଛି ମଧ୍ୟ କଣ ମିଳିଲା ସେଠୁ ଦେହରେ ପିନ୍ଧିଥିବା ବସ୍ତ୍ର ସମ୍ପୂର୍ଣ୍ଣ ପୋଡ଼ି ଯାଇଥିଲା. ଡାହାଣ ପଟେ 5 ପଟ ବାମ ପଟେ 8 ପଟ ଚୁଡ଼ି ପିନ୍ଧିଥିଲା. ମୁତଫିର ଡାହାଣ ହାତ ତଳେ ଗୋଟିଏ କ୍ୟାମେଲ ଦିଆସିଲି ପୁଡ଼ିଆ ପଡ଼ିଥାଏ ଓ ତା ଭିତରେ ଦିଆସିଲି ଭର୍ତ୍ତି ଗୋଟିଏ ଧଳା ଖାଲି ବୋତଲ କିରୋସିନ ଗନ୍ଧ ଥାଏ ଆଉ ଗୋଟିଏ ବୋତଲରେ ଅଧାରୁ ଅଧିକ କିରୋସିନ ଥାଇ ମୁତଫର ଡାହାଣ ପାଖରେ ପ୍ରାୟ 8 ଫୁଟ ଦୂରରେ ଥିଲା. ମୁତଫି ମରି ପଡ଼ିଥିବାର 10 ଫୁଟ ଦୂରରେ 3 ଖଣ୍ଡ ନେଳି ଭଙ୍ଗା ଚୁଡ଼ି ଥିଲା. Cause of death appears to be burn injury. Okay. So, Mr. Mishra, let us say that some evidence has come that when the marriage took place initially, there was some kind of disturbance between the parties and let us say that there was a demand of scooter at that point of time. But the marriage and the death, the gap is 7 years. And the prosecution has not adduced any evidence that even though the deceased had committed suicide, let us go to that, accept that it's a case of suicide and the suicide was committed inside that cow shed. But when the prosecution has not produced any evidence that the conduct of the appellant has got some link with the commission of suicide by the deceased, then how 306 IPC would be established?
Actually, my only ground here that I'm taking is there is continuous ill treatment of the deceased as per the evidence of PW 1 and 6, my lords.
Just a minute. Continuous ill treatment of deceased. किए कौची से विषय?
Lords, PW 1 and PW 6.
ଦେଖେଇଲେ evidence ଆଉ ଥରେ
Lord,
ସେଇ particular line ଟା ଦେଖାନ୍ତୁ।
Lords, PW1, Your Lordship,
ହୁଁ
page 47.
ହୁଁ
That's the fifth line from the bottom, my lords.
ହୁଁ after marriage
My lords,
ହୁଁ
after marriage, my daughter was sent to her in-laws' house,
ହୁଁ
but she had no peaceful living there.
ହୁଁ
On all days, there was quarrel and misunderstanding of the deceased with the in-laws of my daughter.
Hmm.
Sometimes she was assaulted by them. Accused Lakshman was also assaulting the deceased. Accused Hiralal was also insisting my daughter to bring the scooter.
hmm
When the deceased daughter used to come to our house,
Hmm.
she was telling about the assault and ill treatment to her.
hmm
This much part I'm relying on
Hmm.
PW1, Your Lordship.
hmm
So this evidence establishes that, my lords,
so it may bring home the charge under 498A
Lordship.
ବାହାଘର ପରେ ତାକୁ ଇଏ ବାଡାବାଡି କରୁଥିଲା କି ତାକୁ assault କରୁଥିଲା ସିଏ ସେଥିପାଇଁ ଖୁସି ନଥିଲା that but the for 306 something more is required to be proved karan evidence in the cross examination he has stated that prior to we had not complained before anybody regarding demand of dowry or torture on the deceased and this particular part that Lakshman came and threatened that is not there in the previous statement. First time she has stated so.
Lordship.
And coupled with the fact that the person who had visited the house of the deceased, in that means in-laws house, she has not stated anything in that respect. And PW1's evidence, how it is getting corroboration from the PW6 evidence. Come to PW6, let us see.
Lordship. Lordship, may take the third paragraph,
Hmm.
page 59. After the tubectomy operation and the death of the male child,
Hmm.
on consultation with the physician, they ascertained that there is no guarantee of further conception, and as such, accused Lakshman, apprehending no male issue through the deceased, tried to have a second marriage. Because of this reason, the deceased and the accused Lakshman were quarreling with each other, and accused Lakshman assaulted her on some occasion, for which the deceased came to my house. The deceased was also complaining of the ill treatment by the accused Lakshman, and once he was throttling her to do away with her life. In the following December, my daughter was this part has been so I'm relying on this part only, Lordship. To
Again, those things the period has not stated.
Lordship, my humble submission, my lords, is that these acts constitute indirect act of incitement of for the suicide, Your Lordship, under section 306.
No, say gap is such that is why they have consistent used that proximate. Suppose something was happening initially, but that has settled,
My lords.
and prior to the occurrence, something else has happened for some other reason. She has committed suicide. So the accused will be liable for that act which he has done, not that unless you adduce evidence that the death which has taken place, that for that also something was done specifically by the accused. The link ଟା establish ଯଦି ନ କରିବେ, ବାହାଘର ପରେ ଯୌତୁକ ଡିମାଣ୍ଡ ଥିଲା, ଠିକ ଅଛି, ତିନିଟା ପିଲା ତା ଭିତରେ ହେଲାଣି, 7 ବର୍ଷ ଟପି ଗଲାଣି, ତେଣୁ ସେଇ ଜିନିଷ ପ୍ରିଭେଲ କରୁଛି ବୋଲି ଏଭିଡେନ୍ସ ଯଦି ନାହିଁ, ଆଉ ଯୋଉ ଯିଏ ଯାଇଛି ତା ପୂର୍ବ ଦିନ ମଧ୍ୟ କିଛି କହୁନି, ଚୁପଚାପ ମାନେ ଦେଖି ନାଇଲା ସବୁ, ଏଭ୍ରିଥିଙ୍ଗ ୱାଜ ନର୍ମାଲ, ଆଉ ବାପା ମା ବି କହୁନାହାନ୍ତି ଯେ ତାଙ୍କ ପୁଅ ଆସିକିନି ଡିସିସ୍ଡ କୁ ଭିଜିଟ କଲା ପରେ କୌଣସି ପ୍ରକାର କମ୍ପ୍ଲେନ କଲା ତାର ନା ତା ସ୍ୱାମୀ ବିରୁଦ୍ଧରେ ନା ଘରର ଅନ୍ୟ କୌଣସି ସଦସ୍ୟଙ୍କ ବିରୁଦ୍ଧରେ। ତେଣୁ ଏଥିରୁ ଆପଣ କେମିତି କହିବେ ଯେ ଯୋଉ କାରଣ ପାଇଁ ଡିସିଜ୍ଡ ସୁଇସାଇଡ କରିଛି ତା ଗୁହାଳରେ, ସେଥିପାଇଁ କେବଳ ଆପେଲାଣ୍ଟର କଣ୍ଡକ୍ଟ ହିଁ ଦାୟୀ, ଅନ୍ୟ କିଛି ନୁହେଁ।
I'll admit, Lordship, no proximate act attributing to the
That
accused
is the, I think that the decisions which he is referring to, all those decisions under section 306 na,
306.
of the Indian Penal Code states about that. You place the decisions of these 4 decisions, I think 2017 66 OCR एटा किए ଦେଇଛନ୍ତି?
এটা ଆପଣଙ୍କର
अच्छा 862, then
2023 91 OCR
718,
ସେଇଟା ବି ଆପଣଙ୍କର।
अच्छा
ଆଉ ସୁପ୍ରିମ କୋର୍ଟରେ ହେଲା 2011 48 OCR ସୁପ୍ରିମ କୋର୍ଟ
ये सब से proximate link ऊपर कौन सा?
approximately होगा।
So that may be a ground, but how do you escape from the other offenses? 498A, 4DP Act, এই ଯୋଉଗୁଡାକ ରହିଛି 4DP Act ର ଆସୁଛି ସେ scooter demand ବିଷୟରେ ଆସୁଛି ଏବଂ that is consistently I think stated by scooter demand ବିଷୟରେ demand accused Lakshman so demanded scooter ତାପରେ
PW2 has also stated. Independent witnesses have also stated about the demand of scooter.
scooter ଟା ବିଷୟରେ
ନାଇଁ ନାଇଁ ସେ ଲିଖି ତାର କ୍ରସ ରେ ସେ କହୁଛି ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ କହିଛି ଡ୍ୟୁରିଂ ମାଇ ପ୍ରେଜେଣ୍ଟ ଆକ୍ୟୁଜ ଲକ୍ଷ୍ମଣ ହ୍ୟାଡ୍ ନଟ୍ ଡିମାଣ୍ଡେଡ ସ୍କୁଟର କ୍ରସ ରେ କୁହାଯାଉଛି ତାର। ଆଉ ଏଟା ଲଭ୍ ମ୍ୟାରେଜ ଥିଲା
ମା କହୁନି କି ସ୍କୁଟର ବିଷୟରେ?
ମା କହୁଛି ମା ବାପା କହୁଛନ୍ତି ସେ ସ୍କୁଟର ବିଷୟରେ, କିନ୍ତୁ ସେ 7 ବର୍ଷ ତଳେ ବାହାଘର ବେଦିରେ ସେ ମାଗୁଥିଲା ସ୍କୁଟର ଟା।
Brother has also stated.
ତାପରେ ବି 7 ବର୍ଷ ଭିତରେ କେବେ କାହାକୁ କହିନାହାନ୍ତି କି କୋଉଠି ଏଫଆଇଆର ଦିଆ ହେଇନି କି ସ୍କୁଟର ତାକୁ କେବେ ଇଏ କରାହେଇଛି ସେଗୁଡାକୁ କିଛି କୁହାହେଇନି। ସେ PW2 independent witness ଟା ସେ କହୁଛି ସେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛି ଦ ମ୍ୟାରେଜ ୱାଜ solemnized in the house of accused ଲକ୍ଷ୍ମଣ, ମାନେ accused କରାଯାଉଥିଲା in his village, the deceased and the ଲକ୍ଷ୍ମଣ were in love and agreed to marry each other. The parents of both sides agreed to marry each for their marriage.
No, even PW6 ର page 59 ରେ କହୁଛି whenever my daughter was coming to my house on all occasion accused Lakshmana reminded my daughter for giving scooter as committed earlier. ତେଣୁ ଏଇ ଏଭିଡେନ୍ସ ଟା ରହୁଛି ନା ଆପଣଙ୍କ ନାଁରେ। ତ PW5 ଆଉ 6 ର ଏଇ ଯୋଉ regarding demand of scooter, that is
ସେଠୁ ପାରା 6
treatment ର ମଧ୍ୟ
PW6 ର PW6 ତାର କ୍ରସ୍ ଏକ୍ସାମିନେସନ ପାରା 10 ରେ cross examination para 10 ne koji accused Lakshman not personally demanded scooter from me after marriage. I have not reported to the police or to the castman regarding the demand of scooter by accused prior to the death. So also I have not complained the above regarding ill treatment and assault to my daughter.
ସ୍କୁଟର ଡିମାଣ୍ଡ କଲା, ସ୍କୁଟର ଡିମାଣ୍ଡ ପରେ ସେମାନେ ଆସ୍ୟୁରାନ୍ସ ଦେଲେ, ବାହାଘର ହେଇଗଲା। ତେଣୁ ଆଉ କମ୍ପ୍ଲେନ କରିବାର ସେତେବେଳେ କଣ, କିନ୍ତୁ ଡିମାଣ୍ଡ ଟା ପରସିଷ୍ଟ କଲା।
ସେ କହୁଛି ସେ ମତେ କେବେ ପର୍ସନାଲି ମାଗିନି ସ୍କୁଟର କଥା। ସେ PW6 କହୁଛି ମତେ କେବେ ସେ ପର୍ସନାଲି ସ୍କୁଟର ମାଗିନି।
ସେ ପୁରା ୟା ଥ୍ରୁରେ ମଗୁଥିଲା, ମାଗିବ କଣ? ଝିଅକୁ ଏଭିଡେନ୍ସ ଟା କଣ ଆସିଲା କି?
ସେ
ଝିଅକୁ ଯେତେବେଳେ ଝିଅ ଆସୁଥିଲା ତାକୁ କହୁଥିଲା ଯେ ତୋ ବାପା କହିଛନ୍ତି କମିଟମେଣ୍ଟ କରିଥିଲେ ସ୍କୁଟର ଦବା ପାଇଁ, ତେଣୁ ଇଟ୍ସ ନଟ୍ ନେସେସରି ଦ୍ୟାଟ୍ ହି ସୁଡ୍ କମ୍ ଫରୱାର୍ଡ ଆଣ୍ଡ ପର୍ସନାଲି ସେ ଡିସିଜ ଥ୍ରୁରେ ମଗା ହଉଥିଲା ଦାବିଟା।
ସେ କଥା ସେମାନେ ଆଗରୁ କୋଉଠି କହିନାହାନ୍ତି କି ପୋଲିସ ଷ୍ଟେସନରେ କି କାଷ୍ଟମ୍ୟାନ କି କାହା ଆଗରେ କହିନାହାନ୍ତି।
and PW
ପ୍ରଥମ ଥର ପାଇଁ ଏଠି କୋର୍ଟରେ କୁହାଯିବ।
ନାଇଁ ସ୍କୁଟର ଡିମାଣ୍ଡ କଥା କାଇଁ ଆଗରୁ କହିନାହାନ୍ତି?
It is there in the FIR, my lord.
I have not
demand of scooter part is there in the FIR itself.
I have not reported to the police or to the castman regarding the demand of scooter by accused prior to death. So also I have not complained.
ଆଗରୁ ଦେ ମାନେ ଯୋଉ ମରିବା ପୂର୍ବରୁ ଆଉ ଏ ଯୋଉ ସ୍କୁଟର ଡିମାଣ୍ଡ ସଂକ୍ରାନ୍ତରେ କାହାକୁ କୌଣସି ରିପୋର୍ଟ ଦେଇ ନଥିଲା, ତା ମାନେ ହଉଛି ଏଇଆ।
ହଁ, ତା ମାନେ ସେ
so he was ଏବଂ PW7 ମଧ୍ୟ କହୁଛି that the appellant was annoyed for not giving a scooter and refuse to marry unless the scooter is given. Tapare gentlemen thile jemane they convinced. Then the marriage took place. But accused Lakshman asked my sister to bring scooter, and accordingly my sister told my mother regarding so and so.
Cross examination on para 5 रे कहूची I was examined by police on 6/10/97 for first time at our village. I have
There
not
was a demand, again paragraph 5, there was a demand of scooter by accused Lakshman, and his ill treatment to my was made in my presence by accused Lakshman.
I have not stated to the IO regarding the presentation of wristwatch and ring to the accused at the time of marriage and his declaration not to marry unless scooter was given. There was no demand of scooter by accused Lakshman, and ill treatment by my sister was made in my presence by accused Lakshman.
There was demand of scooter.
There was demand of scooter.
There is a demand.
There was demand of scooter.
There was
by
demand of
accused.
scooter accused.
And ill treatment so and so was made in my presence.
କିନ୍ତୁ ସେଟା ସେ police ଆଗରେ କହିନି ସେ କହୁଛି ଯୋଉ ये कहता at the time examined by police on 6/10/97 for the first time at our village, I have not stated to the IO regarding the presentation of wristwatch and ring to the accused.
ସେଇଟା ହଉଛି ସେ ବାହାଘର
ବାହାଘର time
ସ୍କୁଟର ନଦେଲେ ବାହାଘର ହବନି ବୋଲି ସେଇଟା କହିନଥିଲା, ବଟ୍ ସେ ଡିମାଣ୍ଡ କଥା ଆଉ ତାପରେ ଇଲ୍ ଟ୍ରିଟମେଣ୍ଟ କଥା ଏଗୁଡାକ ତା ପ୍ରେଜେନ୍ସ ରେ ହେଇଛି ବୋଲି କହୁଛି। ତେଣୁ ବାହାଘର କଥାଟା ସେ ଯୋଉ ରାଜି ହଉନଥିଲା ସେଇ ପାର୍ଟଟା ସେ କହିନି ଅଛି। So ତିନିଟା witness ତାଙ୍କ ଘର ଲୋକ who are the best person to say, they have stated at least about the demand of scooter and also the ill treatment meted out to the so and so. But you are right that that proximate link aspect is not there. So if that be the case, then this 498A and 4 of DP Act, how many years this man was in custody?
25/4/97 ରେ ଆରେଷ୍ଟ ହେଲା। 25/4/97 ରେ ଆରେଷ୍ଟ ହେଲା। ଆଉ 5/7/97 ରେ ବେଲ୍ ହେଲା।
5/7/97 then conviction ହେଇଥିବ ଭିତରୁ ଯାଇଥିବ 5 ବର୍ଷ ହେଇଛି ଯେହେତୁ 17/2/2001 ରେ ଭିତରୁ ଯାଇଥିବ and କାରଣ 389 ର ତ ପରଭ୍ୟୁ ଅନୁଯାୟୀ ଆସୁନି ବେଲ୍। ଏଠି ହାଇକୋର୍ଟରେ କେବେ ବେଲ୍ ହେଲା ରେକର୍ଡ ଦେଖିଲ? Prayer for bail is allowed. 27/2/2001. ମାନେ ସେଠି ହଉଛି ଆପଣଙ୍କର 5/7/97 ଆର୍ ୟୁ ସିଓର କୋର୍ଟ ଦେଖିଥିଲେ ନା କଣ? ଅର୍ଡର ସିଟ୍ ଦେଖିଥିଲେ? ଟ୍ରାଏଲ କୋର୍ଟର ଅର୍ଡରଟା ଦେଖିଲେ? 5 ଲକ୍ଷ୍ମଣ 25 ନୁହେଁ ସେଟା 26 ରେ ଫରୱାର୍ଡ ହେଇଛି। ବାକି ରହିଲା 5/7 ଦେଖିଦବା। ସେଟା ହୁଁ 5/7/97 ଠିକ। ବେଲ୍ ବଣ୍ଡ ଫିଟ୍ ହେଇଛି ସେଇଦିନ। ହୁଁ 5 ଜୁଲାଇ ଠିକ। ଡିସିସନ ଗୁଡା ଦେଇଥିଲେ ସିଏ ନା ଖାଲି ରେଫର କରିଥିଲେ? ଆଇଲେ ଡିସିସନ ଗୁଡା ଦିଅନ୍ତୁ ଲେଖନ୍ତୁ। ସେ ଇଏ ଗୁଡାକ ଲେଖିଦେବେ ତ ଡାଇରେକ୍ଟଲି ପଳେଇ ଆସନ୍ତୁ ଏଠି। Mr. B.S. Dasparida, learned counsel appearing for the appellant, contended that the doctor who has conducted post-mortem examination has stated that he found no smell of any chemical like kerosene on the body of the deceased. And though the death was due to extensive burn injury, which were antemortem in nature, but he further stated that as the body was extensively burned with charring, it was not possible to say definitely whether it was accidental, homicidal, or suicidal in nature. He further stated that there was no injury on the unburnt part of both the leg and right hand. It is argued that in view of specific medical evidence, so also lack of circumstantial evidence, that it is a case of suicidal death of the deceased, the conviction of the appellant under section 306 of the Indian Penal Code is unwarranted. Particularly when the prosecution has failed to establish any proximate link between the conduct of the appellant with the death of the deceased. And PW7, who is the brother of the deceased and visited the in-laws house of the deceased on the previous day of the death of the deceased, has found everything normal, and there was no complaint made by the deceased before him regarding the conduct of the appellant. The Land Council further submitted that the evidence adduced by the parents that the appellant came to their house while the deceased was staying there and threatened her to accompany him, otherwise she would be assaulted, for which the deceased was sent to her in-laws house, is not deposed to, is not stated before police by any of these witnesses during investigation. and therefore no reliance can be placed on such statements which is being made for the first time in court. It is further argued that in view of the gap of the marriage and the death, which was for more than 7 years, and absence of any clinching evidence relating to ill treatment of the deceased by the appellant or demand of scooter, and particularly when no previous report has been lodged in any police station and there was no complaint before anybody. In that respect, the ingredients of the offense under section 498A of the Indian Penal Code, so also 4 of the DP Act, are not attracted. Therefore, benefit of doubt should be extended in favor of the appellant. Mr. S.K.MISHRA and an additional standing counsel, on the other hand, supported the impugned judgment and argued that even though the doctor bracket PW8 was not sure whether it was a case of suicidal death, but the body of the deceased was found in a cow shed, and one kerosene bottle and one empty bottle was found. And from the circumstantial evidence, coupled with the fact that it's a case of burn injuries as per the evidence of the doctor, it can be said that the prosecution has established that the deceased committed suicide. The Land Council further submitted that in view of the evidence of PW1 and PW6, it appears that there was consistent in-treatment on the deceased, and there was also demand of scooter, and the possibility of the deceased committing suicide on account of such ill treatment or demand cannot be completely ruled out. And therefore, the London Trial Court has not committed any illegality in convicting the appellant under section 498A and 306 of the Indian Penal Code, so also section 4 of the Dowry Prohibition Act. ये जो appellant और contention रे लिखिला ना तापर लिख देवे, he placed reliance in the case of so and so जो चारटा decision अछि ताको दे देवे. Adverting to the contention raised by the Land Council for the respective parties and to adjudicate the cause of death of the deceased, it appears that PW8 conducted post-mortem examination over the dead body of the deceased on 15/3/1997. and he noticed the following injuries. अच्छी quote कर दे. He stated specifically that death was due to extensive burn as evident by antemortem nature of burn. And the same was sufficient to cause death in ordinary course of nature. However, he did not notice any evidence of violence on the body of the deceased. The postmortem report has been marked as Exhibit 6. PW8 has further stated that the IO made a query as to whether the burn of the deceased was homicidal, accidental, or suicidal. And the extent and degree of burn and the possibility of cause of death, etc. And he opined as follows, quote kar de beta. The query report has been marked as Exhibit 7. Number of witnesses, including the investigating officer, have stated that the dead body of the deceased was found in the cow shed, and the IO has seized 2 bottles from near the dead body. One was full with kerosene, the other was empty, but kerosene smell was coming out of it. And the said seizure list has been marked as कितने number seizure list? As Exhibit 8.
8, Your Lordship.
Exhibit 8. Though the London Council for the appellant submitted that the accidental death of the deceased on account of burn injuries cannot be ruled out, but since there is no material on record or any circumstantial evidence that the deceased tried to escape from the spot after receiving such injuries, and in view of the finding of the kerosene bottle and matchstick, and the very report that the death took place on account of such burn injury, I am of the humble view that even in absence of any specific medical evidence, the circumstantial evidence is sufficient to hold that it's a case of suicidal death. However, merely because the deceased committed suicide while staying in the house of the appellant, that too in the cow shed, would not ipso facto bring home the charge under section 306 of the Indian Penal Code. Inasmuch as the prosecution is further required to prove that there was proximate link between the suicide of the deceased and the conduct of the appellant. से डिसीजन गुड़ाक देखले कौन देखा आनिछन से डिसीजन अच्छा अच्छा इन केस ऑफ मदन मोहन এটা কোন 2010 ও 8 এসসিসি কাই সেটা ফ্ল্যাগ বি in case of Madan Mohan Singh versus state of Gujarat এই जोड़ा से खाली मदन मोहन सिंह करिवे सुप्रा कर देबे ऊपर तो लिखा हिथिबो एड़ा अंडरलाइन करछन कोडी
ଆଜ୍ଞା ସେଟା ହଉଛି ଦେଖୁଛି ମଦନ ମୋହନ ସିଂ ରେ ହଉଛି ରାଇଟ ମାରି ଦେଇଛି ସବୁ
अच्छा it has been held as follows paragraph number 12 टा खाली कोट करन नहीं 12 और 13 दीटा पैराग्राफ कर दे है ना नाली पेंसिल टा बड़ा so this is para 12 and 13 है ना तापर होची सेकंड डिसीजन होची
ସେଟା ହଉଛି 44 45 46 49 ପାରାଗ୍ରାଫ ଗୁଡା ଇମ୍ପୋର୍ଟାଣ୍ଟ
तापर ईयर वन जे अच्छा इन द केस ऑफ से जो 2011 डिसीजन टा फ्लैग सी in the case of M Mohan bracket re supra
तारे 44 to 49 your lordship
it has been held कोटा 44
44 to 49
44 ରୁ 49
रुन अच्छा 44 to 44 तो गोटे डिसीजन टा टिपी जंती नहीं तांको निजे ऑब्जर्वेशन तो 45 रू पर्यंत 45 46 45 आरंभ होइछि अबेटमेंट इन्वॉल्व्स मेंटल प्रोसेस ऑफ इंस्टिगेटिंग
lordship
सेठु आरंभ होइछि देन 45 46 पर्यंत तापर छोटा डिसीजन देइछन है ना एंड 49 पर्यंत हाँ माने 45 46 एंड 49 है ना तो एटा मार्क कर दवा ता ऊपर 45 46 एंड 49 तापर आसंतु इयर वाइज अनुଯାୟୀ 2017 ର ହଉଛି ରବୀନ୍ଦ୍ରନାଥ ଦେव ସେଟା କେତେ ଫ୍ଲାଗ ଡି
ସେଟା ପାରା 6 ଟା
ଆଚ୍ଛା ଏଟା ଆମ ଡିସିଜନ ଅଛି ରବୀନ୍ଦ୍ରନାଥ ଦେव କେତେ ନମ୍ବର
ପାରାଗ୍ରାଫ 6 ଟୁ ଆରମ୍ଭ ହଉଛି
6 ଟୁ ସେଟା ତ ଏମାଉଣ୍ଟ ଟା କୋଟ ହେଲା ଅନକେୟାରଫୁଲ ରହିଲା ଏଟା ମଦନ ମୋହନ ଦିଆଗଲା ରମେଶ ହେଲା ଡିସିଜନ ଗୁଡା କୋଟ ହେଇଗଲା ଦେନ୍ ନା ଏଇଟା ଖାଲି ଡିସିଜନ ଗୁଡାକ କୋଟ ହେଇଛି ତେଣୁ your observation ସେମିତି କିଛି ନାହିଁ ହେଲା ତ ସେଇଟାକୁ କାଟି ଦିଅନ୍ତୁ
ସେଇଟା ପାରା 7 ରେ ଅଛି there is no material on record the petitioner instigated or aided any
କୋଉଟା
disease
କୋଉଠି କହିଲେ ହଁ ହଁ
para 7 committing suicide there is
paragraph
no
7 ମୁଁ ତ
nexus of
underline କରିଦେଇଛି there is no better petitioner instigated so and so there is no nexus ଅଛି 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 or any of these so and so ହଁ अच्छी paragraph 7 अच्छी observation ହେଲା then ତାପରେ ରହିଲା ଆଉ ଗୋଟେ decision cite କରିଥିଲେ ପ୍ରହ୍ଲାଦ and others
ଏଟା ପାରା 12 ରୁ ଆରମ୍ଭ
flag E ତାହେଲେ ଏଇଟା ହେଲା ଆମର ଯୋଉଟା ଦେଇଛନ୍ତି 2017 ରେ এটা হচ্ছে paragraph flag D ରହିଲା এটা ହଉଛି paragraph 7 ଲେଖିଦେବା para 7 তারপরে প্রহ্লাদ বেহেরা রয়েছি
paragraph 12
paragraph 12 দেখিও paragraph 12 বললেন ঠিক আছে paragraph 12 ଠିକ ଯୋଉଟାକ ବ୍ରାକେଟ ପୋର୍ସନ ଅଛି ସେଗୁଡା ତ 2023 ର ପ୍ରହ୍ଲାଦ ବେରାଲା paragraph 12 ଏତିକି ତ ନା ଆଉ ଗୋଟେ କଣ ଦେଇଛନ୍ତି
ସେଟା ଗୋଟେ ଇଣ୍ଡିଆନ କାନୁନ ଆସେ ଏଇଟା
ସେ ଥାଉ ଦେଖନ୍ତୁ the PW7 is the brother of the deceased who visited the house of the appellant on the previous day of occurrence. And he has stated that he went there with his friend Bharat with some articles and gave all those articles and stayed there for an hour and came back. And on that day, the appellant was present in his house and the deceased was also sifting grain from the chaff. And he talked with the deceased and stayed there for some time and then came back. He has not stated to have seen any untoward incident or not stated about any complaint made by the deceased before him against the appellant. And PW1 and PW6 were the parents of the deceased have also not stated that after returning from the house of the appellant, PW7 made any kind of complaint against the conduct of the appellant. Therefore, the learned counsel for the appellant is quite justified in his submission that proximate link between the conduct of the appellant and the suicidal death of the deceased is missing. And therefore, in my humble view, the Learned Trial Court was not justified in convicting the appellant under Section 306 of the Indian Penal Code. Now, coming to the charge under Section 498A of the Indian Penal Code, PW1, the mother of the deceased, has stated that her daughter was having no peaceful living in the house of the appellant. And on all days there was quarrel and misunderstanding. And sometimes she was assaulted by the appellant. And whenever the deceased was coming to their house, she was telling about the assault and ill treatment to her. Though this witness has stated further that in the month of March of the occurrence year, while the deceased was in their house, the appellant came and threatened the deceased to go with him, otherwise she would be assaulted. And out of fear, they sent the deceased with the appellant to her in-laws' house. But it has been confronted to PW1 and proved through the investigating officer that no such statement has been made during course of investigation, for which it is very difficult to place reliance on such evidence which is deposed to by the PW1 for the first time in court. Similarly, PW6, the father of the deceased, has stated that whenever the deceased was coming to their house, on all occasion, um, stated that that the deceased was complaining against the ill treatment by complaining about the ill treatment by the appellant, and once the appellant was throttling her to do away with the life. Therefore, the evidence of PW1 and PW6, it appears that the appellant had subjected the deceased to physical and mental torture, and this part of the evidence has not been second in the cross-examination of these two witnesses. Therefore, I am of the humble view that नहीं এটা এটা টিকে ইয়ে লিখো এই সে जो ইয়েটা দিলো আইপিসি র जो 498 এটা support As per the definition of cruelty under section 498A of the Indian Penal Code, it means any willful conduct which is of such a nature as is likely to drive a woman to commit suicide or to cause injury or danger to her life or person. The cruelty can either be mental or physical. It is to be determined / by considering the conduct of the man, weighing gravity or seriousness of his act, and to find out whether it is likely to drive the woman to commit suicide, etc. To decide the question of cruelty, the relevant factors are the matrimonial relationship between the husband and wife, their cultural status, temperament, state of health, their interaction in the daily life, which dominate the aspect of cruelty. The prosecution has to establish the willful conduct on the part of the accused, and whether the conduct would attract cruelty or not. Conduct of the husband would attract the cruelty or not is to be adjudicated in the facts and circumstance of each case. The learned counsel for the appellant argued that the witnesses have stated that there was no previous report before the police relating to any torture or cruelty meted out to the deceased by the appellant, and therefore the evidence on this aspect should be discarded. It is not to be forgotten that the marriage has taken place 7 years back, and the appellant and the deceased are blessed with 3 children.
ଆଜ୍ଞା
3 children.
ସେଥିରୁ ଜଣେ ମରିଯାଇଥିଲା
and the third child died, and one of such child. The as a parent, as the parents, since it's a family dispute, the might be thinking it would subside and everything would go in a smooth way, and therefore lodging of the report with the police may aggravate the situation, and in such a situation, in such a scenario, non-reporting of the matter to the police regarding torture cannot be a ground to disbelieve the evidence adduced by the parents of the deceased, which has remained on second. Therefore, I am of the view that the Lennon trial court has rightly come to the conclusion that the prosecution has established the charge under section 498A IPC against the appellant. Coming to the charge under section 4 of the Dowry Prohibition Act, PW1 has stated that appellant during marriage demanded dowry of a scooter, but the demand could not be fulfilled due to poverty, and it was assured to give at a later point of time on the availability of the fund. In the cross-examination, she has stated that although there was frequent demand of scooter and torture, they have not convened any punch before the villagers or castemen, as the daughter was staying in her in-laws' house. PW2 has also stated that there was some misunderstanding on the marriage day regarding demand of scooter. And for this, the appellant did not agree to go to the marriage pandal unless it is fulfilled. And after persuasion, he agreed to marry, and the father of the deceased promised to give the scooter after marriage, arranging funds. The witness in the cross-examination has stated that during his present, the appellant had not demanded scooter. PW6, the father of the deceased, has stated that the appellant Lakshman demanded a scooter as dowry prior to the marriage, but due to poverty, he could not fulfill the demand. And at the time of marriage, the appellant protested for not giving him a scooter and expressed not to marry unless it was given. And the appellant was persuaded to marry, and on availability of fund, the scooter would be given later, at a later point of time. And accordingly, the marriage was solemnized. He further stated that whenever the daughter was coming to his house, on all occasion, the appellant reminded on all occasion when the deceased was coming to his house. On all occasion, the appellant reminded the deceased for giving the scooter as committed earlier. The learned counsel for the appellant argued that PW6 in his cross-examination has stated that the appellant has not personally demanded scooter from him after marriage, and she has not reported about the same before the police and casteman, for which the scooter demand is not acceptable. When the evidence on record indicates that the demand was made through the deceased, and as discussed earlier, that the parents, they were hoping that the situation would normalize, and bringing the matter to the notice of police would aggravate the situation. Therefore, non-reporting of the demand of scooter before the police or the punch cannot be a ground to disbelieve such aspect. Even PW7 has stated that the appellant was annoyed for not giving a scooter and refused to marry unless it is fulfilled, unless the demand is fulfilled. And then he was convinced and marriage was solemnized. Therefore, from the evidence of these witnesses, it is apparent that there was a demand of scooter not only at the time of marriage, but that demand continued for a substantial period. And therefore, in my humble view, the London trial court is justified in convicting the appellant under Section 4 of Dowry Prohibition Act. In the result, the appeal is partly allowed. The conviction of the appellant under Section 306 of the Indian Penal Code is hereby set aside. However, the conviction of the appellant under Section 498A and 4DP Act stand confirmed. It appears that the appellant was taken into judicial custody during course of investigation on 26/4/1997, and he was released from custody on 5/7/1997. And again he was taken into custody on the pronouncement of the judgment on 17/2/2001 and released from custody on 27/2/2001. The occurrence has taken place in the year 1997, and more than 26 years have passed. And therefore, while convicting the appellant under Section 498A of the Indian Penal Code, so also 4 of the DP Act, the sentence is reduced to period already undergone. Put a note of appreciation on Mr. Das Parida and Mr. Mishra.
Obliged, Lords.